My lord, may I be permitted to mention, my lord?
Yes, yes.
Item number, my lord, 239 of your lordship's combined list.
Yes.
Urgency is that new motion. Urgency is that, my lord, I got an order in the year 2014 upon the, my lord, by the honorable court, my lord, upon the district magistrate Bakura to consider my application on the basis of the old rule 2002 for extension of my lease for mining lease.
Yes.
Now, my lord, that has not been considered. Repeated, my lord, letters, repeated representation were given. Now, my lord, I came to know, my 2025, my lord, I came to know that they are going to, my lord, auction my land in the new rule. There is a specific direction by the honorable court, my lord. Let them consider, my lord, under the old
Who
rule.
is appealing for the state?
Well, I have
State
to,
and the, I think corporation is also
no,
appealing.
no, no, only state.
Only state.
State.
Who is appealing for the state?
Well, I have to,
Please mention after serving notice.
well, fix the matter, my lord, I will serve.
No, no, no. Please mention after serving notice.
May I mention tomorrow,
I
my
will
lord?
take it up on that day itself.
Well, may I mention tomorrow, my lord, after getting obliged, my lord?
My lord, may I permit to mention, my lord, two listed motion, my lord? Yeah, that was in the list, my lord.
Listed motions, please hand over the slip.
My lord, may I...
But please serve notice upon the other side.
My...
Motions, please hand over the slip. New motions, please hand over the slip.
My lord, may I kindly be permitted to mention, my lord, on item number 104 of your lordship's monthly list, my lord. My lord, the urgency is that...
Have you served notice upon the other side?
My lord, there is some urgency, my lord. I shall serve
Please
notice.
serve, then mention.
Lordship,
Yes.
may I permitted one matter, lordship? New motion, lordship.
New motion, please hand over the slip.
Matter mentioning twice, lordship, but it is not...
Mention the urgency, hand over the slip.
My lord, may I be permitted to mention?
Mr. Day.
May I be lordship's kind leave to mention item number 361 of the monthly list.
Yes.
The matter was heard on the last occasion, and after hearing and after my lord appreciating the facts of the case, the learned this honorable court directed the matter to appear as a fixed motion and directed the respondent to file report also. But they have not yet filed the report. And lordship, I'm just praying for some preference in this matter.
Mr. Day, who is appearing for the other side?
Learned AG appeared in this matter for the state.
Have you served notice upon them prior to
If
mention?
your lordship directs something, I will.
Please serve notice, then mention.
May I mention tomorrow, lordship, upon giving notice?
Yes, yes.
I'm grateful to you.
May I permit to mention for inclusion of contempt matter?
Please hand over the.
My lord, may I be permitted to mention a matter? It's an old contempt matter from 2010. I am applying for inclusion. My lord, after serving notice, my lord, I am mentioning one matter, my lord, for inclusion. Motion, my lord.
Motion, please hand over. Yes. Call the list.
Motion item number 1.
My lord, I am for the petitioner.
Yes.
My lord, service not yet completed, my lord. I am kindly direction maybe
Giving a date and you are not completing service.
my lord, my mother was very sick, my lord. She is 80 years old and no one to look after her except me, my lord. I will serve, my lord. Kindly leave may be granted to serve upon the landed GP, my lord. As a matter of...
Serve upon the respondents also, not only GP.
No, no, I will serve, my lord. But without the court's direction, court's order, my lord, learned GP will not accept the copy, my lord.
What is your prayer? What have you prayed for in this writ petition?
My lord, for the for return the unused acquired land, my lord.
It was acquired under what proceeding?
1894 Act, my lord.
1894, it was acquired, compensation has been paid.
Paid, my lord.
So where is the provision for return of unutilized land under the 1894 Act? Please show me. Please show me the provision. Where is the provision in the Act, 1894 Act, for return of the unused land which has been acquired?
My lord, let me serve and come back, my lord.
Please satisfy. May not be any necessity to serve. Please satisfy me on this. Other side's presence is not required. Please satisfy me that there is a provision, because that's your prayer. Return of the unutilized land. So, subject to correction, there is no provision in the 1894 Act for return of unused land. And you have received compensation.
My lord, let me serve and come back. My lord, let me serve and come back. My lord, let me serve and come back.
There is no necessity to serve.
My lord, one chance, my lord, let me serve and come back, my lord. Let me.
What is the necessity? There is no necessity, I am saying. Orders cannot be passed against the other side. So I'm asking you, please cross the first hurdle, then I will see whether service is necessary or not.
Then take the matter tomorrow, my lord.
All right. The learned advocate appearing for the Yes.
I beg to appear on the petition, my lord. May I serve my affidavit of service?
Yes. Private respondent is there, Mr.
My lord, there is no private respondent in this matter. Lordship, what has happened
But
is,
for the state,
My lord.
yes.
Lordship kindly comes to page 32. This is the first round of litigation wherein, my lord, what has happened is, in front of my land, the persons have encroached it and have carried out illegal construction on a highway. I made representation to the highway authorities, but they
State
didn't,
highway.
state highways. They did not take any steps. That forced me to file the first round of writ petition before this honorable court, which is at page 32. After hearing the parties, the honorable court directed the authority concerned to take steps. Pursuant to such direction, the authority concerned took steps. Accordingly, hearing was given to all the concerned parties. And after hearing, Lordship, the order is at page 38. A order for removal was passed. And
This order of removal under 10-1.
10-1. Now, 10-1 was not complied with.
Then 10-2.
Then 10-2. Now, 10-2 notice has been served and 10-2 proceeding has been initiated. In spite of that, the persons have not removed their encroachment. Therefore, Lordship, it's time right now for the respondent to invoke 10-3. They have not done so. I am on this limited point.
That is true, my lord. Last Friday, my lord, we have received this brief, my lord. I shall instruction from this, my lord.
How much time? 10-3 will be completed within how much time?
3 weeks, my lord. My lord, before that, my lord, my learned friend, my lord, submit before your lordships, my lord, encroachment and construction this land, my lord. I am saying this only one thing, my lord. Page number,
Yes.
page number, my lord. He has purchased this land to, my lord, kindly page number 18.
Sir, there is an order under
No,
there's
my lord,
notice of removal
That-
of encroachment under 10-1.
Absolutely
So
correct.
prima facie there is an encroachment. Are you supporting
No,
encroachment?
no, my lord.
So if he has also encroached, remove him.
My lord.
Maybe he has purchased yesterday,
My
but
lord.
that does not
My
authorize.
lord, my lord, that's why, my lord.
Thank you. Yes, where is the 10-2?
Yes, Lordship kindly comes to page 40.
40.
Ashun. provided under the statute by directing execution of that order at that
Very
stage. Thank you.
I'm grateful
Yes,
to you, Lord.
next.
I for the petitioner, Lord.
Yes,
But his service is not complete, Lordship.
yes, madam, what is the relief you have claimed for?
Lordship, the respondent blocks the common passage where the petitioner common path, Lordship. And they made a constructions on this road. The private respondent denied to access to the petitioner.
What is your allegation?
Lordship, they
Who
blocked
has
the,
encroached upon whose property?
Lordship, the respondent and petitioner have a common passage, Lordship.
Yes.
Adjacent property. The
Common passage, common to whom? The petitioner and the private respondents.
No, Lordship, petitioners common. There is a.
You are saying common passage. If you use the expression common, it is to be common for the petitioner and someone else. It has to be common when you say.
Neighbors.
If you say exclusive, it's understandable. If you say common, common with whom?
Other petitioners and other neighbor lots.
Yes, say so. And what is your allegation?
Allegation is that private respondent made a constructions on this Rasta lot.
On the
Road, common passage lot.
road belongs to whom?
Petitioners.
Private dispute, madam. It's a private dispute. If on your private property someone has encroached,
Yes,
it's
Lord.
purely a private dispute. Yes, Mr. Nag, you are representing whom?
Lord, so far as I'm representing the state, Lord. So far as the
If the service is not complete,
First, if I check
it is
out,
representing.
service is
Yes,
not
yes, Mr.
complete.
Nag.
Lord, so far as the whether the road belongs to the petitioners or the government, my Lord, I do not have the instructions. I've sought instructions, my Lord. We have not received it as yet. So I
No, if the petitioner says it's his private property, he has to go before the.
yes, that is, my Lord, that is not
Whose
there.
case is that? So why are you
No, I'm
entering into
I am
this?
not at all.
Ashun, the petitioner alleges Next.
My lord, I am for the petitioner, my lord. The state is also not served in my matter.
Please
my
let me see what is the
Yes, my lord.
relief
My
you
lord,
have claimed.
my lord, 10-3 order has been passed, my lord. I have preferred an appeal, my lord, and
10-3 order has been passed. You have preferred an appeal.
yes, my lord, preferred an appeal, my lord. I made this application, my lord, for disposal of the appeal, and for meanwhile, my lord,
Private respondents have you served?
no, my no, none of the respondents have been served. Not even state has been served.
Disappear. Yes. The 10-3 order has been passed. She has preferred an appeal. Let the appeal be disposed of within a time.
My lord, till the disposal of the appeal,
হ্যাঁ তাই অর্ডার হচ্ছে মাইলর তাই অর্ডার দিচ্ছে
my possession may not.
এনাম এই এনাম
Yes, yes.
কত তারিখে থাকবে মাইলর
23rd of December.
23rd
I am for the statement.
Motion করে দিন। Under the heading motion লিখে দিন, হ্যাঁ? None appears for the petitioner at the time of call. আচ্ছা, Mr. Mahato Laner addiction. Same order, none appears.
Lord, I beg to appear on behalf of the petitioner.
Yes.
My lord, land loser scheme. My lord, land acquired 1 acre.
Who is for the state?
My lord, may I file my affidavit of service? My lord, it was served on the Ministry of Coal, my lord. The other addresses, my lord, it has come back. My lord, may I cause fresh service? It has been some time.
Where have you served? Ministry of Coal.
Lordship,
Coal.
at Delhi.
Eastern Coalfields you have
My
not
lord,
served.
the
Why?
I have served, it's not complete, my lord. May I serve and come back again?
Who appears for ECL? You are appearing. You appear for ECL.
My lord, it is a similar matter, my lord. Both matters can be.
Please come, please come. Similar matter.
My lord, similar matters.
All right. So, do you have an extra copy of this?
My lord, I do not. My lord, I shall serve, my lord, in the course of the day.
Please give a copy to him. All right. At pass over করে রাখুন. To be called on along with 11. 11 এর সঙ্গে এটা ডাকবেন. 11 you are appearing.
Yes, my lord.
11 is the same matter.
My lord, similar matters.
All right.
Same facts, my lord.
ঠিক আছে 7 আর 11 একসঙ্গে ডাকবেন যখন 11 ডাকবেন yes next
Lord, I'm for the petition.
yes
I'm for the state, my lord.
yes
Submit the applicable service, my lord. The land of the petitioner, my lord, has been utilized for widening the national highway number 6, my lord, without giving any compensation or acquisition. And my lord, I have inquired from the office of the
it has been utilized
utilized, my lord. Part of the land has been utilized without acquisition, my lord. If
which
you lord,
plots which are the plots
my lord, plot, paragraph 2, my lord, have indicated. This plot number 1383 and 1389, my lord. My lord, I have
PSN RS plot number 1383 and 1389
yes, my lord. If your lordship kindly comes to page number 17, my lord,
yes
I sought for information and the office of the special land records officer, my lord, land acquisition officer, my lord. Well, it has been intimated that no acquisition has been made,
all right
and I have given an intimation reminder, my lord. No result, my lord. And now I am seeking for adequate compensation as per 2030.
yes have you utilized this
My lord,
plot
in that case, lordship, I need to take the instructions, lordship,
My
because
lord, I have a report. I am for the state, my lord.
yes
This is the report of the.
plots have been acquired or not acquired
It was acquired and it compensation has been paid.
paid
Kindly see page 12, annexure R6.
of your report. At a copy. Page.
what is his name
মঙ্গলময়ী দাসী, wife of Lakshman Chandra Mondal.
Arun Mondol
Yes, ma'am. The grandmother was the
grandmother was the original owner what was her name
Mongolmoyi Dasi, my lord.
Mongolmoi
Dasi, my lord. In paragraph 2, my lord, I have written.
The first one, page 11.
Mongolmoi where is her name yes Mongolmoi Dasi
Yes,
First.
yes.
1383 part
Page 11.
and 1389 page 11
Yes, yes. I've sought for information. Information was given wrongly, my lord, by the department, my lord. My lord, may I come back with instructions such?
why are you giving wrong informations they are fighting filing pay cost of this litigation pay cost of this litigation in such a casual manner you are supplying the information without looking to the records cost of the litigation has to be paid to the petitioner unnecessarily he was harassed
The petition annexed.
Mr. Dev, what is going on another matter I found wrong information acquisition everything done saying nothing this also same thing how these informations are being provided casually without looking to the records who will compensate the petitioner for this litigation
My lord, the petitioner has also has that. When is my lord claiming that?
so they appreciated but he maybe we do not know whether the compensation was list of the awardees maybe whatever might be that could have been a ground for rejection but you have supplied that gave them a cause of action your information he wanted to know
That is wrong, my lord.
so
In other matter, my lord, I appear that it is the land. has
In
been
that matter,
acquired-
you appeared.
Yes, 1956, but the record of rights is still in the name of the. Record of rights, my lord, that is the, my lord, my.
Mr. They, yes, record of rights do not confer title. But why should it not be corrected?
My lord, there is a, my lord, dependency between the two, my lord.
Why? Why there should not be any coordination? Mr. They,
There is requiring body and magistrate, my lord.
no, requiring what? Mr.
Not the
They,
requiring
when the
body.
property has been acquired, is vested with the state.
No, my lord.
No, my lord.
Based with the state, but
Yes.
not in the name of the government.
No,
But
not.
it is the name of
Mr.
the
They,
requiring
not
body.
in the name of the government, but with vest with the state.
No,
So
according
why
to-
should
no,
it
according
not be
to
sent to the
requirement.
office of the Land Reforms Department for correction of the record of rights?
Everybody will send his name, my lord, file an application for mutation, that my name should be not the name of the state government. In
Now,
vested-
Mr. They, I am asking you.
Yes, my lord.
So if a property has been vested,
Yes,
uh,
vested, my lord, if West
under
Bengal-
this scheme,
Yes,
under this act,
yes, sir.
acquisition.
The
Now,
requiring body
if a acquired property, a deed of conveyance is presented before the registrar, what he will do?
Yes, my lord, automatically deed of register will go to the nowadays. Now, my lord, deed of.
So that is why, Mr. They, why are you not making this coordination? If this coordination is when this acquisition proceeding is initiated,
Done. What that is.
now it is being done.
Yes, my lord. Now it is being done after.
Please do that, because
Yes,
for that
automatic-
these litigations are coming. Otherwise, they would not have. And this is also, this litigation is also for providing a wrong information.
Now, my lord, nowadays, my lord, it is on the date of registration that file is sent to the respective BLO.
So that is registration. What are you doing with regard to this acquisition?
Acquisition means, my lord, acquisition, in case of acquisition, my lord.
Yes.
The record will be done by the requiring body, not.
Mr. Dev, you are having the records because acquisition, notification, everything, payment, all is being controlled by your department, land acquisition department. Why you are not sending this information to the land reforms department? If that is sent, everything will be done. I'm not saying it will be recorded in the name of the collector. It has to be recorded in the name of the requiring body. But if this information is sent, that will be done.
Up till now, that was not having it. And because, my lord, this is the mutation is in the name of the requiring body.
Yes.
So for that,
Mr. They, I'm not saying mutation will be in your name. But I'm saying, why are you not forwarding this information?
that process is not up till now, my lord, not.
Why are you not suggesting that? I'm asking you.
My lord, your lordship said, my lord, I must.
Please see, otherwise if this coordination is made, then many problems will be solved, many litigations.
The lordship said, if the land is vested in West Bengal Estate Acquisition Act and West Bengal Land Reforms Act, then my lord, automatically our name of the.
No, that is a different thing. Here your name will not be recorded. I'm not on that. I'm asking you that why this information, this acquisition, this information, if it is sent.
That was not done by the. Said, my lord, I must request.
Because on the, what is the difficulty? Some persons may take advantage of this wrong recording and transfer this plot
Yes, my lord.
to others. He may not know, he will only see the record of rights. Yes, it's in the name of a private party, so he will purchase. This gives rise to various litigations.
Yes, sir. I must talk with Mr. Advocate General.
Yes, please see, because if this is done, many litigations can be, this transfer, some innocent persons may have purchased.
At the date of acquisition.
Now he will have to rush to the private party to recover those consideration money. Look how many litigations.
In the meantime, the private respondent who sold the property, he may die.
Maybe successive transfers may also take place.
Yes.
Please see how this can be solved. The petition.
Scan করে নিচ্ছে আমি।
Nine,
The private respondent has constructed his.
Private respondent served. So they appearing.
Yes, madam.
Yeah, PWD road,
No, my.
National Highway.
National highway.
Yes. Now what happened? Compensation? No, encroachment.
Encroachment. But the private respondent encroach their building on the, by encroaching the.
Yes, madam, what is your instruction?
My lord, at this moment, my lord, there is no such instruction. My lord, if there is such any encroachment, my lord, we'll ready to remove that encroachment, my lord, with the help of the administration, my lord.
Page 16, my revision is, sir.
Consider this representation. Who is the authority to consider? Project director.
Project director, my lord,
Project director, so number 1.
But,
For the respondent, my lord, 3 to 6, my lord. Each respondent. And each activity, my lord, 3 to 6.
ECL.
The land has been captured and enjoying by the CL, my lord. And
Yes.
not get any compensation and or petitioner made representation, but still is not considered. Page, my lord. 44, page 10, my lord.
Yes. Why are you capturing the land of private parties, utilizing that, not
That is
paying
not correct,
compensation?
my lord. Kindly see, my lord, 38, my lord. My land fee is not telling you lordship all the facts. Before, my
telling
lord,
all
they had filed
What
a,
are all the facts?
but that file a writ petition, my lord, before this paper challenging this, my lord.
Yes.
My lord, it is, your lordship will find that order at page 38. There, my lord, kindly see the direction was that, my lord, that document should be produced by the petitioner before the concern, that can be assessed whether the petitioner fall under the scheme or any family member entitled to get appointment.
Oh, they are claiming appointment.
Yes, my lord. My lord, what happened, my lord, in ECL, my lord, this is, my lord, particularly, my lord, land, my lord, of which we have acquired, my lord, in 1982, my lord. From, my lord, 1982 to 1984, my lord, we used to give employment in 1 acres of land. 1 acre, that is in ratio 1:1. After 1984, my lord, from
Now it's
1985.
2:1. For 2 acres, one employee.
One land. Now, my lord, what happened, my lord? This, my lord, the project area, my lord, initially, my lord, we have, my lord, taken 35 acres in which 35 employment was given in ratio 1:1. The subsequently, my lord, again, my lord, 104 acres has been taken, my lord, in which, my lord, 84 employment was given. His land, my lord, does not fall under that area, my lord. This was, my lord,
To which the scheme relates to.
Scheme relates to. Now, my lord, this, my lord, they have come before this court. The court has asked them, my lord, to produce document before the court. Now, my lord, they came and supply us the court. This I am saying, my lord, in 2013, my lord. They give us a document, my lord. In that document, my lord, necessary document to show that they are the owners, my lord, was not there. The High
Owners
Court
of the plots.
of the plot, my lord. This was also pointed out, my lord.
Now have they produced those documents?
No, it's still not there in this writ petition also.
Show me the documents that is the owners of those plots, please.
And, my lord, delay, my lord,
Page, my lord, 21.
21.
Yes, ma'am.
But he has to show that it is falling under that scheme, my lord, not, my lord, his ownership.
Yes, my lord. Recorded on our thanks, my lord.
Oshini Mahato.
Yes, ma'am.
So what are the plots according to you which has been utilized?
My lord, all plots, my lord, page plot number we ever mentioned.
No, you are the owner of these plots. All these plots have been utilized.
Yes, my lord.
That's your claim. All these plots have been utilized. This is lying where? In under Hirapur, Kotian number, Bordhaman, Junut, Muja. Yes.
Muja, Junut.
Yes. So now, according to you, there is a scheme.
Yes, my lord.
Where is that scheme?
My lord, page 23, my lord.
Page 23. Yes.
Already, 7 meters of land has been acquired by the ECL, my lord, and enjoying the matter. My petitioner is a poor cultivator, my lord. His land has acquired, but still yet no response, my lord.
Land history, mine network, mine network, the cooler is near cooler mine.
No, what, Mr.
Not to hear the petitioner with the hearing, my lord, in any occasion.
Mr. Arifin, where is the
My lord, this is
where is the area which has been mentioned in this notification?
Not kindly see, my lord, whether this plot is there or not, my lord.
Plot numbers have been mentioned. Where the plot numbers have been mentioned?
No plot number has been mentioned. Kindly see the reason order which we have passed, my lord. We have considered there.
He is challenging the reasoned order.
Yes, he is challenging the reason order.
Where is that reasoned order?
Page 38. Sorry, my lord, it would be, my lord, at page 42.
42?
42, my lord. Kindly see, my lord, the reason, my lord, there, my lord, we have made up table, my lord.
This order is under challenge.
This is under challenge.
2015 order you are challenging in 2025.
Yes, my lord, exactly.
My lord, petitioner is
No reason given in the writ petition.
not known this fact, my lord. Some other person has filed this case, not informed, my lord. The petitioner, after known this fact, my lord, made representation, same also not considered.
My lord, here, my lord, the plot, my lord, that they have challenged, my lord, earlier, my lord, the plot number is also mentioned over there, my lord, and kindly see the reason is also given, my lord.
Mr. Even here they have produced they are having the record of rights. So I'm directing you to take a decision on this. So they are not challenging this because they were not the petitioners there.
Yes, they were the petitioner, my lord. They were the one of the petitioner, my lord. In this writ petition also. That is the case, my lord. Kindly consider, my lord, the paragraph number 13. The only explanation which I can get, my lord, is paragraph 13. The petitioner state that and submit that the previously the petitioner are jointly filed the writ petition and the Honorable High Court was dispose of the said matter and direct the petitioner to make details representation and hand over the learned advocate of the coal company. But previous learned advocate did not properly guide with the present petitioner and the petitioner cannot able to submit his claim of their prayer of the land compensation and therefore the respondent authority did not take any step in favor of the petitioner. So, my lord, this was before they jointly file a writ petition, and my lord, we have considered and dispose of. Now, my lord, he says that no, that time it was not.
Now he claims his
Yes, my lord.
ownership. He has produced the record of rights now. Now the record of rights.
No, my lord, we are not saying that he is not the owner of the land.
Yes.
We are saying, my lord, his land was not damaged by us. It does not fall under that scheme, my lord. Our project area, my lord. That is our case, my lord. That is the reason, my lord, we have rejected it.
So show me that these plots. These plots were considered in the earlier order. Please show me that.
My lord, kindly see
Plot
that there is a
numbers
table.
are- Plot numbers are. What are his plot numbers?
My lord, my lord, see, here, my lord, a table has been given.
Page 42.
Page 42, plots numbers, my lord. Kindly see, we have to consider the plot
Page
numbers, my
42,
lord.
the plot numbers are no. Where are your plots? Your plot number is 208 and 233 and 285.
220.
No, 208, 223 and 285. 3 plots.
208, your lordship can see it is there, my lord.
Yes, 208 was considered.
223 and
223.
208, my lord, he claims, my lord, 72 decibel. Now, my lord, another, my lord, if your lordship compare it with his
285 was not considered.
285, my lord,
223 was also not 223 was also not considered.
223
was not considered.
My lord, this in a new case he has met out in this writ petition, my lord. Previously, whatever plot he has mentioned, my lord, we had considered. Now, in this writ petition, he is making a new case.
All right, file a report whether these 2 plots are involved or not. If not, then the petitioner claims to be the 11টা কি হলো একসঙ্গে বললাম 11 যখন ডাকবেন
petitioners. Yes. In item 7, she was hearing these are in respect of a land users. If 1 acre of my land is acquired by the whole companies in response to the acquisition process, I will be entitled to one employee. So far as the item number 7 is concerned, I have disclosed documents to show that I have 101 decimals of land. Your lordship sees the first document.
and so far as 11 is concerned,
So far as 11 is concerned, I have documents, but perhaps by effort of inadvertence, I did not disclose one deed to show that I fall within the category to obtain the employment or to be entitled to the employment. But so far as item
is
7
below 1 acre.
So, as per the existing records, item 11, I have one more deed. My instruction is that I have one more deed to show that I have 100 decimals of land, which is equivalent.
You are governed by which policy? 1:1 or 2:1?
1:1.
1:1.
1:1. In both matters, not 1:1. So far as the first matter is concerned, I have 101 decimals. So, I am entitled to one employment. In item 7, the person who.
When these properties were utilized?
Possession was taken long back,
So, how this writ petition is maintainable at this point of time?
There is a previous order, there is a previous order of 2006. I filed a writ petition, and there is an order that the entire process should be completed within 3 months from the date of communication of
So 2006, where is the explanation from 2006 to 2025?
That is not there, but if lordship sees under the scheme, I am entitled to the employment.
Can you come at any point of time? Limitation in service matter, it operates, may not be in acquisition.
I have a judgment of 2022 Supreme Court that perhaps in these sort of cases, courts will be state cannot wash off its own hands. Kindly see this is 2020.
Yes, you have made a representation.
No, there is no representation in terms of this. I don't have the representation that was made in terms of this order because it is a 2006 proceeding. But if lordship sees, we had communicated on 24th of April 2006. This is the order of 3rd April 2006, and this is my representation.
Where is the scheme?
Yes, kindly takes the scheme.
Have you annexed the scheme?
Yes, page 38 of my writ petition in item 7.
এটা কত নম্বর? 17669 টা কত? 11. Oh, in item number 7, which
Item
page?
From page 38. Kindly see capital A for the land purchased, acquired, used between 63 for eligibility. So if I have acquired or if I have used or if I have purchased from 63, then my lord, upon acquisition of
Not from 63, it's 263.
263.
And first part is illegible.
No, it should be 83. Kindly see there is a small.
Where is the original one? It's a typewritten.
Kindly see the previous page.
From 75 to 83.
Yes, kindly see page 37.
All right. Yes, I have seen. From 75 to 83.
Yes, 75 to 83.
So when your property was utilized?
Kindly see, the document at page 20. I have been using, but kindly see the deed of sale. It came from my predecessors. Page
No, deed of sale will not do. The relevant date will be the date when it was utilized or taken over or purchased.
But this is
because it says land purchased, acquired, used between. It's not your purchase that will be relevant. It's if the ECL purchases or they utilize, so that will be the relevant date for deciding which scheme or which of the clauses shall operate. Where is your averment with regard to that when your property was utilized?
By repetition.
Yes. When it was utilized, what is your statement?
But kindly see, the best paragraph is from para 19, page 6.
No. First, you have to say on which date it was utilized to decide which of the clauses will apply.
The person whose land, the document that I am showing, Shantu Mondol, he died. Now, because there is a document, if Lordship sees page 39.
Yes. Yes.
I'm on item 7. I'm on item 7.
23452. Yes, item number 7 is 2345. Yes.
It was acquired from Shamul Kumar Sharma. If Lordship sees page 39, he has nominated the writ petitioner.
No, it was acquired from
Shamul Kumar Sharma.
where have we stated?
That perhaps if Lordship sees the document, that's the best document that I have.
Page 39.
The document, the deed, civil deed is at page 20, and page 39 is the affidavit.
Yes.
Page 39, Lordship sees, I am the absolute owner and possessor of the schedule below property, and according to requisition and acquisition by the authority under ECL Limited, I have sold the scheduled property in favor of Eastern Coalfields by dint of registered Kobala dated 1993 for my employment under the provisions of the
So it does not come within 83.
But kindly see the scheme.
It says admission that he sold it in 1993.
No. Kindly see the scheme, page 38.
Yes.
It says for a land which is purchased,
Yes,
or acquired,
yes,
or used between 75 to 83.
yes. So it's 93.
No, 93 was the acquisition by ECL company. I was in use pre 93.
Not your user, sir. You may be using. It's not your user which is relevant. Why ECL is providing you employment? Because they are utilizing.
Yes.
So you may use it for 100 years prior to that.
Yes.
But that is not relevant. It's the user by the ECL. So according to this affidavit, you have sold it to ECL for the purpose of utilization. So
But there
is
has been a
the
situation.
starting date is 93. So clause A will not apply.
That document, it says that perhaps the registered Kobala was in the year 1993.
Yes.
But before the registered deed being executed in terms whereof the ownership was transferred, ECL had already entered into my land.
Show me where is that. You have to state that fact, sir.
Gives me an opportunity to use a supplementary affidavit. I'll give the relevant averments. Perhaps it was the relevant averments are not there, but I have taken instruction. The situation was that old gentleman, they were having those lands. ECL entered into the land. They had taken possession. They started mining activities. Now, since I came across the scheme, I suggested that since you have taken over the land, I will be entitled to one employment. I am executing a registered Kobala.
Now you have purchased from this Shamol.
No, Shamol is the original owner.
You are whom? You are Shamol.
No, I am nominee of Shamol. Nominee of
Nominee
Shamol.
means?
No, because Shamol.
How are you related to Shamol?
Same family. Same family.
Who will be getting?
My lordship sees I am entitled to, because in terms
Same family? How? Same family? In what manner?
Yes, kindly see, no, I have a genealogical table also. I am the brother's son of Shamul Kumar Sharma.
Family defined in this.
No, there is a genealogical table. There is a genealogical table.
No, I am asking you, this scheme defines family.
No, if lordship sees, yes, kindly see, A Roman 3 at page 38, which is the scheme. Nominee should be near relation and be dependent to the land loser. Upper age limit is 35 years and should be physically fit on medical examination. See, if it is a near relation, I am entitled to get the benefit under the scheme. And if lordship sees the genealogical table.
No. Nominee should be linear dependent of land loser. Can you be said to be a linear dependent of the land loser? Please satisfy me.
Well, lordship, page 38.
Page 37, the scheme.
I'm on the typed copy. This is not
I'm on the original copy.
Yes.
I can read that.
Yes,
The nominee should be linear dependent of the land loser.
No, in
Show me the
lordship-
genealogical table,
No,
whether you come within that linear
no,
dependent.
lordship, see page 37 once. A row.
I'm at 37.
Yes, but nominee should be near relation.
Near relation has been defined. Then see, it has been clarified.
Yes, for land.
There it says near. Now, who can be nominated is a linear dependent.
No, I am the brother's son. If lordship sees page
Show
13.
me your genealogically will not be a linear dependent. Brother's son will not be a linear dependent. Not in line.
No, my lord. Shamul Sharma, my lord, left behind Noah's. Shamul Sharma, my lord, left.
Where is the genealogical table?
Page 13, lordship sees.
Yes, sir. What is your instruction?
My lord, in this case, I have been advised by your lordship to come out with this code. But my lord, I should say, my lord, one thing, the land which was came into use, that was after 84, my lord. First of all, my lord. And secondly, my lord, what
This
I
land
came after for the use, that is after 1984. Because what the scheme they have come out with 1:1, that was prior to 31st December 1983. That was the last date that came up. But the use started, that is later in 1984, my lord.
with regard to this plot.
Yes, yes, my lord. And secondly, my lord, what I see, my lord, is a speculative purchase which has been done, my lord.
Because when this purchase was made,
my lord, in item number 11 also I see.
No, it's 7 when
My
this
lord, the
purchase.
similar things are there, my lord.
Yes.
Here also the two dependents in item number 11, already the person who has sold to the petitioner, that is the petitioner's father, Santanu, died in 2021. So the petitioner's father got out a deed executed in 87. So prior to 84, that was 87 was done, speculative, and two people who has sold to the Santanu already got the employment. They took over.
Oh, after employment they have transferred.
Yes, my lord. That was a speculative purchase that has come up. I'll come out with the report, my lord. Even in the same thing. In 2006, what they say, my lord, we've passed on the reason order in 2007, my lord. After 18 years of exercise now, they
File your
came up.
affidavits.
Yes,
Asun.
sir.
7 and 11. ওই আইটেম নাম্বার 7 এ না সেভেনটাতে শুধু রেগুলার
That is page 64, annex PA. At the land of
with for the state. Have you served?
Served earlier, my lord, but
Served earlier? You are here, yes. Any private party?
no, there is no private party.
Yes, what is the dispute?
Dispute the land of the my lord, mother of the petitioner was acquired. My lord,
Father of the petition was acquired.
my lord, in the year 1980. Thereafter,
No compensation paid.
compensation, ad hoc compensation was paid. My lord,
Acquired under what proceeding?
my lord, this is a proceeding under my lord, the West Bengal Requisition Land Continuance for Act 1951. My lord, thereafter, my lord, I filed a writ application. My lord, just PMHA was need to pass an order. My lord, on my lord, 2nd of February 1996. My lord, directing the my lord, the authority concerned to assess compensation, and ad hoc compensation was paid 10,000 rupees in respect of my lord 24 decimals of land in the town of Jhargram.
In the town of?
Jhargram, in the heart of the Jhargram town. My lord, thereafter, my lord, that was not complied with, I filed another writ application. That writ application, my lord, Honorable Justice N.K. His Lordship then was pleased to pass order on my lord 17th of June 1990, directing the authority to my lord, if no proceeding was initiated, to initiate the proceeding and complete the my lord process. My lord, thereafter, that was also not done. My lord, thereafter, I filed another made a representation, another writ application. And my lord, Justice Mantha was pleased to pass an order. Your lordship kindly come to the order passed, last order passed by my lord, Justice Mantha, page 60. My lord,
60?
60. My lord, his lordship was pleased to direct my lord, the authority, my lord, to pay solatium and interest in respect that my lord land, because my lord, it was I came before this honorable court after a long time delay, in spite of the order passed by this honorable court on two.
Oh, since compensation has been paid, only solatium and interest.
Compensation was paid, my lord, that is ad hoc compensation.
But this direction was to pay only solatium and interest
Yes,
on the
yes,
compensation already paid.
Yes, yes, my lord. That
There was no other direction.
No, that's why, my lord, I am my lord, pointing out your lordship. I am, my lord, concerned with the solatium and interest. My lord, thereafter, my lord, the authority, your lordship, kindly come to page 64.
Yes.
Page 64, authority passed an order.
Yes.
My lord, that order was passed on, my lord, 19th of September 2018, but that was brought to the notice when I filed a contempt of before this honorable court, and they, my lord, this order was, my lord, placed before the court. I have challenged this order before you. My lord, in this order, they have taken the stand. Since there is no provision under the my lord Act for solatium and interest, you are not entitled. My lord, they did not challenge the order, my lord, passed by my lord Justice Mantha. They did no appeal was preferred. My lord, no recalling was application was made. Well, this stand has been taken by the authority that you are not entitled.
But if there is no provision under the statute for payment of solatium and interest, how that can be directed? How can a writ of say you can approach under the contempt jurisdiction?
Yes.
But if in a writ petition it is to be directed, so unless there is a provision in the statute, how there can be inaction on the part of?
They cannot themselves modify the order of this honorable court. Well, they could prefer an appeal or recalling that order. They did not do that. You know, see, I specifically stated.
I think it's better to be placed before his lordship. Placed before his lordship this matter.
Well, I filed a contempt application. On contempt application.
Yes, contempt. What happened? That's pending.
No,
Disposed of.
Upon holding.
Upon holding,
it has been complied with. It has been complied with.
It has been complied with.
Holding that it has been complied with.
Your Lordship, kindly come to the, my lord, order passed by Honorable Justice.
Page 77, my lord.
77.
My lord.
Page 63, my lord, that is the order. Next, the P7.
No, please see, the effect is dismissal, because dismissal, the court directed them to pay solatium and interest. Now, the honorable judge took note of the fact that they have declined, thereafter dismissed your contempt. What remains?
My lord, the contempt was dismissed on the ground.
Mr. Sinha, you have to apply your mind. Please take steps. I'm not saying anything.
My lord,
I do not.
my lord, when the
Because, but if I have to independently go into this, it's a different thing altogether. But here it says, noting that solatium and interest was not paid, they have not paid by the order, has dismissed your contempt application when the original order says solatium and interest. So there might be many interpretations on that. I'm not opening my mouth on that, but you have to take steps because contempt application was dismissed, taking note of that.
and that's
Whether a separate writ petition is maintainable or you have other remedies.
when the separate writ application is maintained because this order, it
Mr.
was
Sinha, I'm not for a moment suggesting, subject to correction by you, I'm not saying that a second writ petition is maintainable for implementation of an order passed in an earlier writ petition. I'm not for a moment saying that. Now, if let us suppose I'm giving you another example, the writ petition in a writ petition an order has been passed directing consideration, alleging alleging inaction, contempt application has been filed. Now, in the contempt application, the order has been placed. Usually, what happens? Yes, order has been passed. All right, contempt application disposed of, liberty given to take steps in accordance with law. So that means you can challenge that order. Here is a different case. Here it's not giving you right, but holding, dismissing after noting, because the original order says this is to be done. Court took note of the fact that this was rejected, then dismissed.
well, since the order was
Interpreting that order, I think this should be done by, I should not want to enter into that. And if you want to move the writ petition afresh, then I will go into those provisions. Because prima facie, it's there is a finding. After noting that,
well, dear Lordship, kindly, my lord, may I once again
please
place-
take steps, because rightly or wrongly, some order has been passed against you. Because if you are saying that the court, the authorities could not have sat in appeal over the order passed by the coordinate bench, the other argument which you have to, which is staring at your face, is even after noting that fact, contempt was dismissed.
Yes.
Because that would have been a direct contempt, overstepping the order of the court. Considering the fact, contempt dismissed. What do you want now to do?
my lord, dear Lordship, kindly grant me leave to withdraw this.
Grateful.
Please apply your mind.
Yes,
What
yes,
steps to be
yes.
taken? Yes, I'm coming after 5 minutes.
13. না না তুমি এনেছে ও আর মনে এনেছে ও তুমিও আমি তুমি আমার leader।
Yes.
এনেছে কি বলতে হবে সেই
Side of the NH6.
Yes.
There after purchase and set up a shop room. After shop room, the private respondent obstructed to be used in front of land because he is claiming he is the owner. Claiming he is the owner.
Who is claiming to?
Respondent.
Yes. The owner of a plot of land.
The
Adjacent.
the National Highway of 6. After purchasing, previously it was set up the petrol pump. After purchasing, I will set up a shop rooms. After starting a business, private respondent claiming that in front of my land, in his name, and the recorded owner is claiming.
Who is for the private respondent?
NHAI is the answering respondent and the private respondent. None of them are here.
You are for the state.
Union and state.
You are for the
Union of India.
My lord, as per
And my lord-
read petition, my lord, there is some, I think, my subject to my senior pet correction. My lord, as per my record, the land was never acquired by the NHA, but it belongs to, from the read petition, my lord, page 26.
Page 26.
The read petition, it shows that NHA or the special land acquisition officer has never, in 62, 63, an acquisition took place, but the land was that time not acquired. NHA's acquisition took place in 2026. In 2012, NHA has acquired the land. The NHA has given the notification and also
when National Highway has acquired?
2012, my lord. My lord, kindly see.
Where is, you have the document?
My lord, I have the documents, my lord. They have given a report and also the
No, he says that
notification.
he says that in front of his property, National Highways.
But these two lands were not acquired by the National Highway because it belongs to West Bengal government.
District, page 26, my lord.
But which department, it cannot be ascertained. But,
No, but you are the owner of which plot?
Adjacent plot.
What is the number of your
Adjacent
plot?
and different Mauja also.
Number my 159, RS plot number, RS and EVA plot number 159, 160, 161, and 163. And in front of RS plot number 392 and 393.
So this, according to you, is the government land. 392 and 393. LR plot number 603 and 604. Yes, what is your instruction with regard to 603 and 604?
My lord,
What is the government land?
603 and 604.
my lord, as per that annexer, it belongs to government, but not acquired somehow. But let him make the PWD and the my lord special LA and the
Page 26 you said.
page 26 of the read petition from the special
So
land
plot numbers have been mentioned.
mentioned.
Oh,
So it
603
was
and
excluded from the proposal.
Your letter it was informed that as per our case record and documents, LA case number such and such, Mauja such and such, J number Jamoni, RS plot number 392 and 393, corresponding LR plot number 603 and 604, respectively, were in the name of district board.
West Bengal
So that above noted plot
were excluded from the proposal of that LA case number 62 and 63.
But this is the government land.
My lord, may I make a suggestion? Which may, if my learned senior friend could get the ROR, over there the Khotian number will be mentioned. But if the
no,
state government,
they
then
say it's in the name of the district board.
has to be in collect.
That's the information supplied by the special land acquisition officer.
Khotian number is not mentioned.
And were not acquired by them.
These two plots were not acquired.
By them. And they have also given the entire notification with the plot numbers.
Yes, implicate the PWD as a party.
PWD, SDO and BLRO. Because competent authority, district magistrate cannot help here.
But one thing, kindly see page number 19. 144 case was started by the private respondent.
Jilla Parishad
Yes.
district board.
PLRO revenue inspector was one report. But kindly see the type of
Page
19A. Type copy. Page 19A.
খতিয়ানটা মেনশন করে দিলে ভালো হবে কালেক্টর খতিয়ানে আছে কিনা দেখে নিলেই
Type
Yes, so it's adjacent to the national highway, but it's a PWD land.
PWD, SDO, and the competent authorities is under the State Highways Act, SDO. Or the under the Unauthorized Eviction Act. Zilla Parishad also we made party because of that. As per that
District board.
District board. All have to be made party.
But if it is a road, it is maintained by the PWD, then it counts.
Jilla Parishad, district board also maintains some roads. Jilla Parishad.
Yes, whether the district board or the PWD, if it's maintained and control of the PWD, then it counts. So, yes, but here, yes, the RI has said PWD. RI's report is PWD. So, there is a confusion with regard to this. Which page? Page 19.
That is his representation.
That is his representation.
His representation.
Page 26 that
19 page is the report of the dealer.
কি করে দাদা তাহলে
সীমানা চিহ্নিত করা আছে।
আচ্ছা আচ্ছা রিপোর্ট আড়াই
That's the report of the RI.
yes yes
For the petitioner, my lord. Well, the adjacent to my land, my plot of land, my lord, there is a plot of
Item number
14, my lord.
14,
For
yes.
the petitioner.
For the private respondent.
Affidavit.
Yes, civil suit is there. Yes.
But also
The
supplement.
appearance, I know that there is a civil suit.
A lot of supplementary affidavit, my lord, because there was some error in the cost element. I've corrected.
Yes, yes.
But the adjacent to my land is a plot of land, LR number 2269, my lord, and that is in the front side of that LR, my lord, is a government land used as 9 Julie leading to the PWD road. The private respondent were making illegal construction in that in the PWD land belonging to the government, my lord. But during the pendency of this petition, the PWD has taken action, and the construction has been demolished. But my lord, the again recently, my lord, in the same part of land they have brought offloaded plenty of bricks, and they have made the intentions clear, my lord, that they want to make another. They will start the construction once again.
Who is for the state?
But I've served, my lord.
When have you served?
It's been filed last year, so that third. It was filed at the time of filing, my lord. Served at the time of filing.
Yes. Yes, but this
Well, kindly come to their prayer portion.
The 3rd of October 2024, my lord.
you are served.
Yes.
3rd of October
2024.
2024.
This was filed long back, my lord.
Page number 12, my lord.
Yes.
Prayer A writ of nature in the nature of mandamus, commending the respondent authorities, either jointly, such as severally to take appropriate steps against the respondent numbers 11 to 12 for encroaching the government land and making illegal construction in the government lands. Thereafter, kindly come to their representation, page 18. That is paragraph 1. Paragraph 1. They have described that by virtue how they have acquired the land. However, they have admitted that they are the owner. The petitioner is the owner in respect of plot number 2269 and 2279.
2269 and 2279. Yes.
This is their property. Well, kindly come to paragraph 2. I am in actual possession of the said land, and I have already constructed two brick built house building in plot less than 0.99
Paragraph
decibel of
2.
house. Paragraph 2 of representation, page number
Okay,
18.
representation,
Page 18. Fourth line from bottom.
In respect of RS, which is just adjacent to LR 2269. So,
No,
yes, constructed on 2279.
Two-story brick built house building in plot number less 0.99 decimal of house land. They are construction upon house land, no conversion. That is point number 2, my lord. Thereafter, kindly come to their on this plot of land. They have already filed a title suit. Title suit, my lord, for declaration and also for permanent injunction. Declaration in the nature, my lord, kindly come.
You have a copy of the plane.
Yes, yes. Declaration in the nature that the plaintiff, that is the petitioner, has right of road frontage over B schedule property, that is impound land, which is impugned in this writ application, to have an access to said public road, and for permanent injunction restraining the principal defendants from making any construction over the B schedule property, B schedule that is impugned in this writ application. Land encroaching a scheduled property, obstructing road frontage of the plaintiff to access public road, and for mandatory injunction directing the principal defendants, that is the private respondent, to remove illegal construction made by the principal defendants over B scheduled land. This is the title suit they have filed for declaration and for injunction. In that suit, they have also filed an application for injunction. Ad interim, initially they have obtained, and time to time extended, but that is not absolute. Have not till date that has not been made absolute, my lord. 14.
Yes, what do you say?
Not only that, my lord, I have also filed an application for local inspection. Kindly see the last page of the report of the local inspection.
Yes.
The report of the advocate local inspection, advocate commissioner, number 1. My lord, have got it, my lord.
Yes, yes.
I have found suit property situated just adjacent to Metal Road from Bhakuri Mode to Horiharpara. I also found some banana trees, and the defendants claim that they have planted, that defendants means I, the private respondent, have planted those trees. I have found no construction is going over the suit property. That I also found neither any quantum of sand, stone, chips,
All right.
or
Yes,
any.
what do you
that is-
say?
So far, my instruction is concerned, my lord, the PW has already taken action, and the construction which they made have been removed. But very recently, my lord, they have again offloaded.
Civil suit is there.
But my lord, they are doing the construction in.
Maybe you have a civil suit filed, same relief you have claimed. Awesome. This application under I'm keeping this. You have
Copy.
you have a second copy. তাহলে ওটা taken on record
Yes.
করে দিন। Please give a copy to your learned friend.
All right.
He must be, his clients must be having that.
Yes.
But give it to him.
I appear on behalf of the petitioner. This is a writ petition challenging an order dated 28th of August 2024 passed by the Deputy District Land and Reforms Officer. I am the owner of by way of a registered deed of conveyance of a portion of
So
land.
there you are for the state.
Yes, ma'am.
I am for the private response.
What is the order which you are challenging? August
Page
28.
107, 28th of August 2024, on the grounds of violation of principles of natural justice. On two grounds, Your Lordship, I had repeatedly asked for relied upon documents to be supplied to me, but only the application without annex was
Pass under 54(3).
Lordship.
Right,
Your Lordship,
it's there.
but Your Lordship, kindly appreciate if I can show Your Lordship that there is a violation of principles of natural justice. Your Lordship
Please
can entertain under Your Lordship kindly knows the judgment whirlpool. Lordship, kindly bears with me for 1 minute. Let me show the documents to show that I have repeatedly demanded for the documents and the documents were not supplied. Lordship, I am a registered owner.
You cannot take that point before the tribunal.
Your Lordship,
You cannot take that point before the tribunal.
but Your Lordship, I am also entitled.
Sir, it's one thing to say 226 is maintainable.
Lordship,
It's the other thing to say when a properly constituted tribunal under a specified act has
Lordship.
been constituted, whether it can be bypassed.
But
Please consider L. Chandra Kumar.
Lordship, but
And the High Court's jurisdiction under 226 has been curtailed by virtue of the West Bengal Land Reforms and Tenancy
But Your
Tribunal
Lordship,
Act.
it is attracted if I can show from the face of the records that there is violation of principles of natural justice. Kindly takes up Your Lordship page
Sir, even if you show
97.
that, it's the discretion of the court.
And Your Lordship, may I humbly beseech Your Lordship that in
So
that
please don't
Lordship,
bypass the remedy because it is the forum which can decide both on facts as well as on law.
Lordship kindly takes up one document, page 97.
Yes, what is the document which was not provided to you?
Lordship kindly takes any of the Your Lordship only the after demanding. I was only supplied a copy of the petition without the documents. Your Lordship kindly takes up page
What is the
97.
order which was challenged under 50?
Lordship, they are challenging my mutation. I have purchased the land from by way of a deed of registered conveyance, got it mutated, got it converted. I'm running a factory therein. From 2014, mutation in my after 2016, I got my mutation. In 2024, they come up and challenge saying that I have purchased it sometime in 1990s. So, Your Lordship, they file an application challenging my mutation. Thereafter, in the appeal court, Your Lordship, I kindly takes up page 97.
What did the revenue officer do?
Lordship, I received this notice from the appeal court directly.
What notice?
Your Lordship, that this case has been filed. Kindly takes up
You are challenging the notice.
page 95. No, Your Lordship, the order. The order. Page 95 is the notice. The order is 28th of August 2024. Page 107.
No, 28th of August 2024. Page
107, Your Lordship. Kindly also have a before that, Your Lordship, kindly have a look at page 97.
No. Where is the original order from which this appeal was preferred?
Your Lordship, that is my mutation. Your Lordship will find that.
Your Lordship, may I
Don't
file
that order.
supplementary affidavit in opposition? I have annexed that order.
We want to file affidavit in opposition. So
I want
need to be admitted.
Lordship, this document
Good
can be
choice,
seen.
sir.
Your Lordship, this document can be seen.
Please wait. Yes, please show me the original order.
Page 92 is my mutation, Your Lordship. They have challenged this mutation in the favor of
Page
the
92.
Page 92. May you
No. Where is the order passed of
Lordship,
your
this
mutation?
this is the mutation.
From whom have you purchased?
Lordship, my deed of conveyance is annexed page 19 onwards.
Page 19 onwards.
Lordship.
Where is the order granting mutation in your favor?
Lordship, that is not that the mutation
Were
is
they hard?
Lordship,
Were they hard at the time of granting mutation?
Lordship, there was no claim at that point of time. I have
So
the
that-
earlier
So
the
that
earlier
is
name.
a violation.
No,
So if you
Lordship,
want the
my
read court to entertain,
Lordship, my
I will
violation.
go to that.
Lordship,
If the parent order is without giving any opportunity, I will set aside that.
Lordship, the parent order is not before Your Lordship. The mutation is.
Can go under 226. I can go to all the orders.
Then Your Lordship
So
will
if you are
kindly.
alleging violation of principles of natural justice here,
Yes, Your
so I
Lordship.
can go to the parent order to see whether there was a violation of the principles of natural justice. Please show me.
Parent order
that-
is not on record before Your Lordship now.
Please, you have got the parent order.
Lordship.
Yes, please give me that.
First DLR order.
The page 33 of their opposition.
Lordship, there is no deed.
Page 33 and 34, Your Lordship.
Yes, what is your right?
Your Lordship, deed number and other details are missing.
What deed number?
The registered deed number
Yes.
is missing in the parent order.
No, in the parent order.
Lordship. Bottom of the page number 33. Mode of transfer, sale deed blank, deed number blank. Next page, registration office blank. On that score, the appellate authority directed to hear afresh.
This order has to go on that.
But Your Lordship, kindly appreciate
does
what is my learned
It does not
friends.
contain anything.
Lordship, kindly appreciate what is my learned friends locus standi.
Maybe.
Lordship,
Let it
he-
be. Let
I
it be
have
considered.
bought by
But
way of registered deed of conveyance.
Let an opportunity of hearing be given to him.
Your Lordship,
So
then
this order cannot stand.
Lordship, then kindly appreciates the appellate court order, sets aside my mutation without granting me an opportunity to deal with those documents. Kindly sees that.
Which documents?
Your Lordship, kindly take up page 97 of my writ.
It has been remanded to the block land and
Lordship,
land
after setting my mutation aside, Lordship,
has to be. Otherwise, it cannot be.
Without hearing me.
If you want, it's one thing whether you can challenge or I can supply reasons why the appellate authority was right in doing so. Because on the face of this order cannot stand.
Lordship kindly appreciates one thing. Lordship, page 97. I request for the documents. Kindly takes up page 97.
Yes. What documents you want?
Your Lordship, the relied upon documents on the basis of which they are challenging this mutation. I am not even aware. Kindly takes up page 97, 13th of August 2024. Lordship, kindly takes up paragraph 3. That my client under the caption memo has been informed that the next date of the hearing has been fixed on 13th. However, no documents has been supplied by your office to my client. So there's a specific request, and even before this, Lordship, I should be aware of on the basis of which the challenge has been made. Let it be remanded back to the appellate authority after serving me the documents, Your Lordship. Let them not set it aside without me dealing with their documents. Lordship, kindly remand it back to the appellate authority to consider it afresh after supplying copy of the documents.
What documents?
Lordship, that is why I am unaware. That is what I am unaware. What are they?
Say what documents? They have only given you a hearing notice.
But Your Lordship kindly appreciates.
Given you a hearing notice. Were you hard or you are not hard?
No, Your Lordship, I was there and I have specifically requested for these copies. Kindly seize.
No, what copies you want, sir?
Lordship, they relied upon documents on the basis of which
let me
they
see
are...
what is the order. Respondents were directed to file a written notice of argument if any the
Lordship, until and unless I know what on what basis they are challenging.
appeal was by you.
No, Your Lordship.
By me.
By learned friend. Lordship,
Private
kindly also take
This appeal
was by the private respondents. I have a mutation in my name.
Till date, Your
Land
Lordship.
converted, factory operating, I am in possession. Lordship, kindly takes page 104. I again ask for the documents.
no documents were considered.
Your Lordship, kindly.
Please see. the order. It contains the reason, page 107. So you are asked to file the written notes. You have not filed. You may have sought for some documents. Please see, please look at the order. What are the grounds? The only ground is it appears from the order sheet of the mutation case in such and such that the portion, something is written there, that the land schedule portion of the deed number is blank and the date of the deed is 1/1/1900. This was recorded on the face of that. Now, after perusal of the documents of both parties, it also appears that there may be technical glitch of the software as the said mutation case is disposed of in the period of transitional phase of the modern software development. Therefore, in the light of the mutation case is hereby set aside, not on merits. So it was directed because this order sheet do not contain anything. What's wrong in that? You appear before the BLRO. I'm directing the BLRO to dispose of within 2 weeks. What's the harm?
Lordship
You
will
will
kindly
produce-
kindly protect me to this extent that this setting aside should not be given effect to. Lordship, if they want to hear us, we will
When
appear.
this order was passed, 28th of August 2024. So it has been set aside.
Lordship.
So you are without any recording from August 2024 till December of 2025.
Lordship.
So I'm directing them to hear it out within 2 weeks.
Lordship.
Same position, 1 year you are without any recording.
File the writ petition in the year 2024 itself.
Maybe, but you are without any interim order. So that
Lordship,
position is
subject to-
continuing. I'm directing Mr. De to fix our hearing within 2 weeks to hear both of you.
Subject
and
to what falls from your lordship. Your lordship, this setting aside on the ground that there was a software technical glitch, I will be suffering unnecessarily because of no fault of mine.
Sir, within 2 weeks, you have suffered for more than 1 year.
So I'd file the writ immediately, but
For 1 year, you are suffering. I'm directing within 2 weeks to consider. What's the harm? You will be producing the document. It will be restored within 2 weeks.
lordship, without being influenced with your observations, any observations in the appeal court order. Whatever be it, your lordship.
Ashok.
We are for the petitioners, ma'am.
Alright, 16, my lord, I beg to appear for the respondent number 678.
This may be kept on record, ma'am. My lord,
Respondent numbers?
678.
6,
6
7.
to 10, my lord. Respondent numbers, private respondent number 6 to 10.
Yes, what is the allegation?
Encroached, my lord, irrigation department's land, roadside land, and thereby, my lord, obstructing our ingress and egress. That is why,
Government land is 1962 Act.
my lord,
You are trying to invoke 1962 Act.
my lord, kindly see the annexure P3. Respondent number 1 has already taken cognizance.
Where?
At
Page?
Page 23 at annexure P3. Respondent number 1 wrote to the respondent number 4 to take steps, ascertain the encroachment and proper steps to be taken. That has not been done, my lord, by the respondent number 4.
Let's suit pending by and between the parties. We are the co-sharer. Just in order to, my lord, get hold the ingress and egress, they want that writ petition, my lord, so that they will succeed in their, my lord, relief basically. The suit is not they are doing anything. The title suit number
What is the plaint?
But plaint I don't have. I have the only, my lord, searching copy. I can.
What do you say? This pertains to this jurisdiction or other jurisdiction?
This is, my lord, superintending engineer. So, my lord, your jurisdiction. All the.
So you complete these proceedings?
Yes, my lord.
It is under which act?
That is 1964 Act. Superintending engineer Kongshaboti Sarkul.
And perhaps that land is no longer in the state because, my lord, in the acquisition proceeding, I have a order, my lord, with me where it holds that no land has been acquired by the state. The LA proceeding, my lord, is.
With regard to this?
My lord,
Yes.
perhaps.
It is the land of the irrigation department.
No. My lord,
All right, then
EA
file a
appeal
report, Mr.
number
Jeffries, file.
423 of 1961.
The petitioner alleges
Well, this is my application. Well, the petitioner is the recorded owner of the plot of land. Well, the water and irrigation department, without any acquisition, excavated some portion of land in between two plots and utilized the same. I raised objection. Ultimately, I came before this honorable court. Justice Pattanayak, my lord, kindly see page 21.
Have you served upon the state?
Yes, my lord.
Yes, who will appear? Mr. Banerjee? Can you appear?
My lord, earlier occasion, Mr. Day is there in this matter.
Earlier occasion, Mr. Day appeared.
Item number 17.
Oh, yeah.
Yes. What is your instruction?
I just got the instruction, my lord. I haven't read it.
Tell me what is the instruction.
I haven't read it, my lord.
Give it to me.
My lord, according to the Director of Registration and Stamp Revenue, the market value of the land is 21 lakhs and something. And another plot is 6,000 and something. 61,000.
What are your two plots? 3377, 3378.
3378. They have assist 6,000 and 2 lakhs something. Where is Mr. Dev? 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 Where is Mr. Dev?
What is the extent of the plots? How much area?
Near about in two plots, 26 decimal and 28 decimal. It is adjacent to Metal Road. my lord.
Yes, how have you calculated the valuation at 2,24,000?
Now let me come back, my lord.
It's the market rate. So is it the circle rate? So I will fix that rate for that circle
Yes,
for
my
all
lord.
registrations to be done.
Yeah, according to director for
For
registration.
all registrations to be done, those roadside plots of this has to be assessed at that value, because now it's not the, that was the difference. While acquisition compensation and registration was different. But if you apply the market purchase policy, then it has to be the market value. Then you cannot take the plea, that has to be different. So I will fix this as the circle rate for that area.
Gotcha. Great.
Please take instructions with
My
regard
lord,
to
let
that.
me come back, my lord.
So whether this circle rate, I will fix this, they will have to fix this circle rate for that area. And this will be applied all throughout. Whatever market price you will ascertain under direct purchase policy, that will be the circle rate for that area.
My lord. My lord.
Tomorrow,
My lord. Day after
why?
tomorrow.
Only one decision, yes or no, whether that should be the circle rate or not, or you will reassess according to the market price.
Day after tomorrow, my lord. My lord, day after tomorrow.
What is the latest deed which has been executed in that registration office? Please bring a copy of that. How have you assessed the market price of that, and on the basis of which, what is the query you have made? So that can be applied to this without directing you to further reassess, because you will again not reassess in that particular. So bring a recent deed of that locality, adjacent plots, the latest deed which was executed after 2016 policy has come. That rate can be applied, or the other alternative is this should be fixed as the circle rate, and any registration done is to be refunded, stamp duty is to be refunded. These are the two alternatives, you can choose one of them.
My lord.
Unreasonable value you are quoting at the time of purchase, you go for acquisition, sir. Go for acquisition, make it why they will accept this direct purchase policy. First you will utilize without acquisition, then he will force them to accept this direct purchase policy. This is not done.
Let me come back, my lord.
দাঁড়ান এবার senior এসছে। Yes, Mukherjee. This should be the circle rate for that area, the rate which you have ascertained. Because this purchase policy market price. This
But-
should be the circle rate.
But what?
Or you can bring the latest deed, registered deed, at which price you have assessed the stamp duty. Because this purchase at the market value, this is not the compensation, how we will be fixing the market value as per the Land Acquisition Act or the 2013 Act.
But
Or you go under the 2013 Act. Three alternatives.
kindly give some time, my lord. We will take instruction.
Take a reasonable approach, Mr. Mukherjee, while fixing the compensation amount. You will utilize another one's property without following any steps. Then you will force him
Now, my lord, kindly
under the direct purchase policy at the rate which you will be assessing.
Now, if your lordship see once, but the market value of the said land was given by the district register, which is
That is what I am saying. So I will hold district register as given. This will be the circle rate, and I will direct production of all the registered deeds of that period, and I will direct refund of the stamp revenue collected in excess of this value. That is why I have said I accept this, the district registrar, and I will direct him to file a report as to the rate at which the stamp duty was collected from the parties as in a conveyance.
kindly keep it on Monday, my lord. By this, kindly.
Today is Monday.
At least we need some time.
Only one thing, whether this should be accepted as a circle rate or the other thing. Day after tomorrow.
But not, instead of day after tomorrow, kindly give some time. But if we don't get the instruction again, it will be adjourned, my lord. Kindly keep it on Monday, my lord.
That I know how the instructions come, Mr. Mukherjee, I know. I know how to bring the instructions through you. The
Kindly give
Mr.
I will.
Mr.
I will
Mukherjee, only a current registered document
Your Lordship
information
has-
query
Your
will
Lordship has
be
given all
through email has to be forwarded
Your
to
Lordship
you.
has given all the thing 10:30 top everything. Kindly give some time, my lord. Kindly give 10:30, my lord, Your Lordship.
পরের দিন করে দিন কবে রেখেছি বুধবার বলেছি বৃহস্পতিবার টুয়েলভ করে দিন 12টার সময় করে দিন ওনার অসুবিধা আছে 10:30-তে আসতে পারবে at 12 Mr. Mukherjee, that's a Thursday at 12 or 11:59 I will keep. He will be saying Barwala.
Matter, my lord.
Preparing for the state led by Mr. Gade.
My lord, the point involved is, my lord, my land has been acquisitioned, it has been utilized, but till date, no compensation has been paid to me. Kindly text my representation once, my lord, at page 30, my lord.
30.
30, lordship. Therefore, get compensation money.
Yes, what is the instruction?
Instruction not yet received, my lord. Instruction is not yet received. My lord, let the representation be considered.
That is.
Acquisition was 68-69. Representation made 2024.
No, that is one thing, but whether you have acquired, if you have acquired, you have to pay compensation.
Lordship.
More so if it is of 68-69, your duty is to pay compensation. You have to, if it is not acquired, you can.
Representation was made 2024, my lord.
Maybe, my lord,
Like
but
to
it has been
consider
acquired
whether-
quite a long time ago.
Yes, file a report.
Yes, my lord.
The learned advocate appeal.
Some lordship.
Yes, next.
Team 19.
1819, I am on behalf of the.
You are for the petitioner?
Yes.
Yes.
My affidavit of service, petitioner's father is the previous owner. Petitioner is the predecessor in interest. The land of the petitioner's father was acquired and the compensation was paid. But
Compensation paid.
compensation paid, my lord, but the structural reward as per the notification dated 28th April 1993 was not paid to the petitioners. My lord. Annexure P4, page 27, the notification. So the land loser certificate issued both the father and the son, the petitioner also. Land loser certificate is on the next page, my lord. Page 30.
Yes, Mr. Banerjee, what is your
My
instruction?
lord, I have not received the instruction, but from the writ petition it appears the land was acquired in 1971. 74 the compensation was paid. Petitioner was born in 1977 or 78, as per the affidavit. Now in 2023, an application has been made for a benefit of a circular of 1993. So they have to first establish the circular at page 27. It has a retrospective effect because it says it shall be given, page 27. Now, the acquisition is of 1971. Whether it will cover that, number one. Secondly, my lord, it says, paragraph 4, that no awardee identified on family should get any land as authority. Is to take care of the family at the time of eviction only. Family means family consists of parents, minor children, unmarried daughter.
Yes.
He's coming because he was not born at that point of time. And there are other brothers.
Did not come within the definition of family.
Minor son. Possibly he's not coming because he was not born. And there are other brothers. He's admitting that. He's saying that the father has given a declaration that all right is given to him. So other brothers are also not before your lordship. He was unborn, and whether this notification will apply because it is not specific that it is retrospective.
But page number 30, the chairman Huldia notified authority already issued a land user certificate on behalf of the petitioner.
Then why did
And
he didn't
user
approve?
certificate is the different thing. Where is that certificate?
Page 30, my lord, P5.
This was when? This certificate was issued when?
Not clear.
Not clear. Date was not mentioned. It's
7071. Case
Case number 5 of 1970-71. And his representation is 2023. December 2023.
In 1993. So, Mr. Banerjee, this certificate, the date is. What is the date of this circular? The certificate?
Not
It is not clear.
Not clear. It is not there, my lord.
It appears that it was for that purpose. What is RAC?
The circular came in 1993.
So he wants a plot.
He wants a plot of land.
His father was the owner.
Father was the owner.
He was evicted because of this.
Now, whether it is a homestead, first he has to satisfy it was a homestead land.
My lord, kindly
Then
come to the page 26, P3, the RTI report.
Yes,
Uh, the structural award compensation, my lord, the second column.
cannot be a homestead. Oh, it was a homestead land.
My lord, when a structural compensation being paid,
Structure ought to have been there, Mr. Banerjee. If a structural compensation was paid,
maybe first not the application of the applicability of the circular, whether 93 circular will apply to the 70.
the other thing is whether he
Coming within-
constructed on a homestead land or an agricultural land, then you will not be getting. If you have constructed on an agricultural,
Agricultural land.
cases that you will be getting a homestead land for a homestead land. But if the land on which you have constructed merely by saying, but that presupposes,
Record of-
because otherwise you will be not be giving the
If the record of
compensation.
right, if the record of right is agricultural land,
You will not be paying compensation then.
we don't
Then you
know.
will take all those objections. No, how could you make this construction? Because the rate will also be there. Because the land, rate of the land, classification of the land, and the valuation of the structures. So then we will raise objection. No, it cannot be, you cannot get structures. But since when you have
That is one
given
thing- one
paid
thing,
for
Lord.
the structure, it supposes that it was a homestead land.
First hurdle. Then, Milord, next is whether this circular is Milord retrospective, covering 70 acquisition. Number 2, he'll have to satisfy. Thirdly, Milord, the other brothers. He says father has relinquished his right in his favor. That cannot be done.
Father has
relinquished all right in the property to one son, to this son.
Through affidavit.
Through an affidavit.
Where is that?
That statement he has made, Milord.
Page 22.
Page 22 is the affidavit, and he says that. So he has to implique the other brothers. They might have a claim. Para 3, he has stated.
No, but the affidavit has the annexed.
Yes.
Page.
Page
22. Page 22.
এরকম ভাবে দেয়া যায় দানপত্র হয় নাকি
No.
What is your name?
Kumar Patra.
Sukumar Patra. He, কবে পড়েছে এটা? 95.
now it's 25
And then the question of delay will come, Milord. If 1995 this declaration is given, and Haldia Development Notified Authority has given him the certificate, he is approaching the writ court, making representation in December 23 and filing the writ in 2025.
Might there is a representation, my lord. I'm not sure about it.
Representation is not very legible. পড়তে পারছো এটা?
এটা কিছু দেখাই যাচ্ছে না
And government is page 3, paragraph 3, page 5. Petitioner states that the father of the petitioner who died leaving behind the present petitioner and other sons during lifetime of the father to avoid future complexity made a declaration in favor of your petitioner to the effect that the present petitioner will get the benefit for the acquisition of plot number so and so.
No, Mr. Banerjee, to whom it will be allotted? To the family or to a person?
Milord, the family will get.
Identified on family,
27.
not get any land as the authority is to take care of the
Persons
family.
losing homestead.
Is to take care. Oh,
Family means family consists of parents, minor children, unmarried daughter.
so the purpose is for the benefit of the family, cannot be for one person also. This is the object of the circular.
To give shelter the family.
So other brothers, not by way of
As
this
the authority is to
declaration
take
cannot be-
care of the family at the time. So when you are evicting a family, maybe the land was in the name of one person, But the object is to protect the family, so it has to be in the name of all, not in the name of your name only.
But before that, no persons losing will get.
Yes, but even that person losing, but his family may not be for him, because that is clarified. No awardee. So awardee will be the person whose name identified should not get any land, as the authority is to, so he
Take
will
care
not
of the
get the
family.
land. Take care of the family at the time of marriage. Family means. So maybe you are the award, you have may receive the compensation, but plot is to be given to the family because it's for the purpose of protection of the family. Many things are there in this scheme, sir. The Banerjee representation has been made.
Lordship will kindly not take note of the objections because
What
before the-
objection?
that not the applicability of the circular.
You
that
consider this.
He was unborn and Lord,
Mr. Banerjee, you consider this pass an order.
we shall pass Lord, but I don't know the authority. Lordship will kindly records not these objections in the order. Then Lord,
All objections. So
kindly record
all objections,
specific
and if you
objection regarding
feel any other person who may be necessary, you may ask him to.
yes. Unborn son, retrospective, not retrospective, and other persons.
Mr. Banerjee, this is
And
the
delay.
authority has not taken these objections from 2023. They have said.
No, these are my submissions.
So now you are taking these objections.
The authority will not, in view of the delayed
Maybe
approach.
the authorities will not take these objections.
There are many
I
things.
prejudice the mind of the authority by making those.
These are legal points which should be considered while considering this application because other
That you
sons,
can,
they might not.
that it's well open to you, Mr. Banerjee, to advise the authority how they will proceed.
But if my submission is recorded, not the authority is at least before your lordship, I can take the sub points of law.
The
Now, the state of petition, my lord, what has happened, my lord, in this case is, my lord, the petition.
Yes.
Petitioner, my lord, the same prayer, my lord, with regard to non-payment of compensation. If it's
Compensation.
yes, my lord, kindly comes to page
I thought
30.
allotment. You said same prayer.
No, my lord, the compensation has not been paid. Page 35, my lord, kindly takes once. We have made an application under RTI, and what is the answer, my lord? Second paragraph, my lord.
Yes.
Page 35. As per office, this office records case number so and so had been acquired vide case number so and so for squatters colony under notification number so and so. But documents viz possession certificate, PLA plan and papers relating to the payment of awards are not made available in this office. So admittedly, my lord, the land has been acquired, my lord, but with regard to the compensation, they says, my lord, we do not have any document.
Refugee Relations Commissioner, have you made him a party? You have not made him a party. This SPI has written to him. He seeks documents from him.
But my lord, Deputy RR Commissioner.
Mr. Banerjee, you will be representing the Refugee Relations Commissioner also.
My lord.
So what is this?
I will be not taking the first point, my lord. The identity of the petitioner is very doubtful.
Identity, why?
Because, my lord, he has claimed through a Hebanama. Hebanama is at page 16.
1953.
Registered in 1953. And he has accepted as a major. So in 1953, he was more than 18 years of age. Kindly come to the affidavit portion, my lord. His age, 73 years. How is it possible? Then he would have been 1 year of age. How he could accept the Hebanama? Whether at all this is the person to whom the property was gifted or not, that is very doubtful. Absolute dapper. Kindly come to the affidavit.
Yes, Mr. Vasu, only what
73
you
years
say.
of age.
My lord, kindly
Have you
see, my
seen
lord.
your client? No.
And Hebanama
No, my lord.
in 53. How is it possible? He is accepting as a major. He says, father has died, you are looking after me, you do namaz regularly, I am satisfied with you. 1 year child cannot do namaz regularly and will not
But
take
in
care of the
Millard,
grandfather.
in RTI Millard, Lordship will find Millard.
Mr. Vasu Malik, he is disputing your identity.
Major.
Say that, Mr. Banerjee. Maybe she may be of ripe age, but
maybe
but cannot say with definite
No.
conclusion that he is no more.
close
That
to
is
100,
not-
close to 100 years, because he was a major taking
Close to
care of
100 years.
taking care of the
You'll be
grandfather.
finding in newspaper some reports
Yes, yes.
here and
Yes.
there. There is some.
But this cannot be the person, my lord.
16.
Yes, Mr. Basu Malik, you do not know whom you are
No, they
representing.
No, my lord.
Page 16 was 53.
53.
She come for affirming.
No, he has come to my lord, Mr. Hossain's
He look
chamber.
Yes. I'm putting question to Mr. Hossain through you. That is why I'm asking. Has he seen him?
Well,
No.
make it day after tomorrow. I shall make it day after tomorrow.
Whether she has
I shall call the
attended
petitioner. No, I will call the petitioner. I will call the.
No, I'm not asking.
No, I will call. No, when Mr.
He
Banerjee has
should-
take this point,
No, because they are on the face of the record.
when Mr. Banerjee has take this.
Mr. Basu Malik, I'm
He has accepted as a major.
production of the petitioner from
Malak.
the present, but you remain satisfied that whether this is the person. Otherwise, serious consequences.
I will. That's what I'm saying. They make it day after tomorrow. I shall.
No,
I shall.
minor bole nahi.
Please
देखो,
be
minor.
certain that whether that person is the
Same person.
same person who has filed this.
Malak. I shall. Malak.
And but you have to make that RR department a party.
yes,
You make
Malak.
that.
That leave may be granted, so that we shall make.
On the prayer of Mr. Basu Malik. 3rd December, under the heading new motion. Yes, next.
21.
At 21, I am for the petitioner, madam.
I'm for respondent number 10.
State.
Hello.
Number 10 is the private respondent. Yes. Yes. What is this?
My lord, this is a matter of, my lord, illegal occupants over the, my lord, national
Illegal?
highway. Illegal unauthorized occupation in construct on the highway, my lord. My lord, can kindly come page number 21, my lord.
State highway
My lord.
or national highway?
National highway, my lord. My lord, petitioner made a representation over the concerned authority regarding, my lord, unauthorized construction has been made on the PWD land, my lord. And my lord, concerned authority, my lord, as per my
Yes. What is your instruction?
my lord, as per my
Yes, state. What is your instruction?
I have not got the instruction. This representation has been made, Lordship, what I found in the page number 21, 22.
Well, kindly see what are the annexures in this writ petition. Well, what are the annexures in this writ petition? Just a representation. There is no evidence, nothing of encroachment.
all are here,
You have not
my lord, all are
encroached.
here. My lord, as per my
It is
Only an inquiry will be made. A demarcation will be made.
my lord,
if
there
there-
is a national highway, my lord. There are small temporary shops over there.
Constructed by whom?
My lord, there are multiple.
Your shop
multiple
is there.
Yes, my lord.
If it is encroached, it has to be removed.
Well,
If it has not been encroached,
this person is alleging that her ingress is being obstructed. However, that is not
may
the
not be the ingress and egress may not be encroached or may not be obstructed, but even then that does not give you right to encroach upon the highway.
My lord, I
So
have
let the
electricity.
authorities find out if there is any
I
encroachment.
have
My lord, as per-
electricity bills.
my lord, as
My
per
lord,
Yes, your authority
for my lord.
maybe, sir, but the fact is whether you are paying electricity by encroaching upon the highway or not, that is to be looked
My lord,
into.
no,
Even if you pay electricity, that does not
no
authorize your
complaint has
occupation
been made
to
by
occupy.
the PWD, my lord. No complaint has been made by the PWD till date, my lord.
That is why I will ascertain that whether you have encroached or not.
My lord, as
let
per
the
my
PW
representation, my lord, BLLRO, my lord, find out an inquiry, and in the report, my lord, it is clear that there was an
inquiry made.
My lord.
My lord, there is no supplementary. My lord, we have.
Madam, you don't have the instruction with regard to demarcation the petitioner has.
My lord, if a
Lord,
copy
kindly
may
come the
be
relevant
given to us,
portion
then
of this, my
I'll
lord,
take it
paragraph number
back
2, my lord.
back, my lord.
My lord, petitioner along with my lord respondent both are my lord illegal construction over there, my lord. Petitioner along with my lord respondent.
Your will has to be also removed.
Lord, as
Petition-
per
Instruction
as per
also has
their
to be
report, my lord.
removed.
As per their
But the petitioner is also unauthorized.
Yes, yes, yes.
Both are having.
His structures will also be removed.
my lord. My lord, my lord.
Rest assured, that will also be removed. It's not only your.
My lord, a copy may be given to us with.
Yes,
this.
yes. Yes, Mr. Dhar, what is your submission? Why are we allowing encroachments?
We are not allowing.
Yes, yes. As petitioner, you want to take advantage of Section 8, that permission, and as state also, you are supporting encroachment. Either way, for either of the parties, you are supporting encroachment. Either way.
As soon as your lordship passes an order, will demolish all the encroachments.
Why do you read the order of the court, Mr. Dhar? I am asking you. Is it not your responsibility to see that there is no encroachment? Or you do not know that there is an encroachment? Please let it be ascertained that whether it's within your knowledge or it's beyond your knowledge. Yes, within your knowledge or beyond your knowledge. So you want a writ petition to be filed, then after that report to be filed, some orders, then non-compliance, contempt to be filed. Then maybe after 5-10 years, you will say, yes, yes, now I am complying with. How soon you will take steps?
As per the statute, will demolish everything.
How soon? I'm asking you. You will complete the entire proceedings
Entire proceedings by
till the appeal, 10-4. Yes, someone will challenge. So it will go up to 10-4.
appeal. I am not in a position. Next course of action.
That is
the
why we will say that appeal
first-
is there.
First round.
Since one party has
First
approached
round
the
within 12 weeks. 12 weeks.
12 weeks. Demarcation done, Mr. Dhar. Demarcation
Then
done.
around 8 weeks.
So
Within 8
you so after demarcation, what is your duty, Mr. Dhar, as per the statute? What you have to do? After demarcation.
That demarcation has to be circulated amongst all the parties, all interested parties.
Do this. Sir, you have the copy of 2 more reports. Because state is not having. Please give a copy of the
I have
report.
only one copy, my lord.
Yes. Circulate to the state. State is not having its own document. Supply to the private respondent.
My lord.
So, yes, Mr. Dos, copies are now circulated. You did not be worried with that. Now it has been circulated.
Then madam, make it 6 weeks.
Well, there are other 3 private respondents, whether they have been served or not, my lord.
You are not representing, madam. They will.
My lord, I'm
they
only
will be-
representing
You are representing?
only a private respondent number 10, my lord.
Yes. So, just be assured with regard to private respondent number 10. Others, Mr. Dhos client will take care of the others. The petitioner claims to be
Well, this is my the petitioner is the recorded right of owner of the land. But there is a canal in between two plots. One is 15392 and another is
বই লাগলে এখান থেকে নিতে পারো।
বিশাল ল্যান্ডের
মানে আমার লাগবে কিন্তু এখন।
দাদারা তো কিছু
হ্যাঁ হ্যাঁ দেখে নিন। Yes, yes, Mr. Bose.
দাদা একটু
Yes.
দিয়ে দেন না
in between two plots there is a canal, DBC branch canal.
In between two plots.
In between two plots. One is 15392 and 15392 Bata such and such. Now the irrigation department, without any notice for acquisition.
You are the owner of two plots.
Lordship. The record of right is here. Change the direction of the canal. For such 11 decimal of land which is valuable and fertile for irrigation, they have merged into the
canal.
They have made representation to consider, pay compensation, damages, penalties.
Yes, sir. They, what is your instruction?
My lord, we will consider first, my lord, as because, my lord, there is a demarcation and other things will be done. Respondent number 4 will consider that representation. He file a press representation, my lord. Representation is not up to the mark.
It's not up to the mark. Yes,
Yes, my
where is
lord.
the representation?
That
Where is the representation, Mr. Bose?
My last annexure, my lord, page,
Legal notice 8824.
Yes, my lord. Page 28, last annexure. 14 December 2025.
And that is, my lord, Sripolli AC, AC মানে কি? DI of DI circle. সে কি লিখেছো এটা?
কোনটা?
না, ওটা না, পরেরটা?
Yes, you have requested the BLRO to make an inquiry. What happened? The BLRO has not done anything, Mr. De.
My lord, then BLRO will, my lord, your lordship will please direct that BLRO will consider.
What?
এই এক দাঁড়াও না, তোমার my lord যেটা ধরেছে ঠিকই তোমার ফেভারই তো ধরেছে। বলছি my lord,
Inquiry was made.
My lord
was made. Yes.
Where is the report?
Report is not there, but I came to learn from the office of the BLRO, the page 29. That the Purvo Bardhaman field inquiry, but since there no information and intimation from your end, as such, I again request to
So
make
inquiry
payment
was
of-
made. Then Mr. De, please take instructions. Please file a report.
My lord, your lordship can dispose of this matter. Directing the BLRO will give the report to the irrigation department and irrigation department will consider that aspect, my lord. And if that was.
Say that please come with that instructions that the BLRO has prepared the report. Otherwise, it will be because it has been stated. For that, you file a report. Need not be in affidavit. What is the
Yes,
fate?
my lord.
What has been done? Ashun. The petitioner.
Time for the petitioner, my lord, in this
Yes.
matter. My lord, before I start with the matter, my lord, the before I begin with the matter, my lord, this annexure P1 is the record of the rights, but it's a very old record. I have tried to give a
Annexure P1.
yes, my lord, as much legible copy as is possible. Otherwise, I have the originals.
What
with
is
me,
your
my lord.
P1s?
Yes, my lord. Now, my lord, these petitioners had the plot of land, my lord, and they have received the land from their original under the Chota Nagpur Tenancy Act, my lord. 1908 and subsequently the West Bengal Amendment Act, my lord. Now, my lord, in 2010, suddenly the state respondents, they came up stating that they would be needing some portion of the land for some social afforestation purpose. My lord. Everything, nothing on written, my lord, everything verbal exchange. Some permissions were granted back in 2010, my lord. And now, like, my lord, the area where the afforestation plantations were made, my lord, that part is looking like a forest now, my lord. Now, in 2021, my lord, suddenly this the forest department comes and started making new plantations, my lord. Now, when the petitioners started making RTI
What
application,
is your plot?
my lord, that is paragraph 2, my lord, my CS DAG number 381, RS 1352 and 380.
RS 1352, it has been vested.
Yes, my lord, that is, my lord, kindly looks at the
Vesting order, madam, you have to challenge.
no, my lord, kindly looks at the 3 replies of the RTI, my lord.
Yes.
3 different RTI replies, my lord. Now, my lord, annexure P3, page 23, these were my query. This was regarding the 1352, my lord. That is page 23. Now, my lord, kindly looks at page 26, my lord. All information.
What do you want now? What is the relief you want now?
My lord, my land has been taken up and is being used for social afforestation. No sub.
Vested, madam. If you were agreed by that, you have to challenge that order of
My lord,
vesting.
we do not have any information. Even that is not there. With
Now they have said, now you have to supply the, you have to challenge that order.
It is not available in the records, my lord. Kindly looks at the.
Yes, where is the order of vesting?
Lordship, Mr. Somnath Ganguly, in this matter, he is leading me. He is no more in the panel, Lordship. That's why I am paying some.
There, madam.
I have not get any instruction, Lordship. Give me some time, Lordship.
This matter was pending from
long back, my lord.
long back.
Yes, my lord.
So,
my lord, kindly comes to page 31 once, my lord.
What can be done in a writ petition? The vesting order cannot be set aside in a writ
My
petition.
lord, they are saying there is no notification, nothing is available with them. No vesting order, nothing. That is the admitted position, my lord. Page 31. My lord, kindly thereafter sees page 32.
Where is the RS record of rights?
My lord, I have the original record of rights. I have annexed as P1, my lord.
This is not the RS record of rights.
Yes, my lord, because my lord, even that is not available. That is also the state's reply, my lord.
Yes.
Kindly sees page 32, my lord. The recorded owner of such and such is the collector of Purulia in favor of the state. And page 31, they say the same land is recorded in the as a forest land, my lord. Now I do not know where to find out also, because there was no vesting notification. We did not receive anything, my lord. That is the only difficulty, my lord.
State land, you have to challenge. That order cannot be challenged. Writ petition, how that can be decided?
My lord, whether there was a vesting at all, my lord, I had sought.
That cannot be gone into the writ petition. Whether there was at all a vesting or no vesting cannot be gone into the writ petition.
My lord,
please,
they have.
Please challenge, take step. Ashun, the petitioner
trouble in ingress and distress. Lordship,
Yes.
Lordship may come to page number.
Private respondents, have you served?
Lordship. Lordship.
Received?
Lordship.
Yes, what is their instruction?
Service.
Kindly see my page 3 of my section.
What is the instruction?
The revenue inspector inspected the land, a measurement has been made, and it has been forwarded to the BLL order. Page 3.
This was in April. What happened thereafter?
Thereafter, the block development officer, actually, he has not made a party of the assistant engineer.
Lordship, I have made the party of executive engineer, Lordship.
Assistant
Come to
engineer
page
Engineer is not the
Lordship, please come to page number 31, Lordship.
sorry. Engineer is not the appropriate
Lordship,
authority. Assistant
as per the
engineer-
government order only, Lordship. Page number 31, Lordship.
31.
This was the last document that I have received. And the inspection was also done.
No, this was in May 2025.
Lordship. Subsequently, no information, no steps were taken, Lordship. I was compelled to file this writ petition, Lordship. The inquiry was also made. After this notice on 27th, the inquiry was also made. Therein, verbally, they communicated to the private respondents that they cannot be there. They have illegally encroached upon the land of the PWD. All the parties, the executive engineer, the public works division also came, Lordship.
This is public land, not
Lordship,
PWD roads.
PWD.
Under what provision these steps were taken? Land. Land is public land eviction of unauthorized occupants act. I do not have
1962.
determination.
Yes, sir.
For want of determination. Yes, land I do not have. Roads. Land 1962 Act, I do not have determination. Yes, next.
25 Lord, I appear for the state.
Yes.
And if your lordship kindly go through the writ petition.
The nature of public interest litigation.
Not nature, my lord, there is no case made out. Kindly see, my lord. Paragraph 2.
He says public interest, you are saying no case.
No case has been made out.
Shows the
But according to
petitioner-
me, subject to correction.
Shows petitioner has a case, Mr. Man.
Another, kindly, your lordship is ultimate, my lord, your lordship. Your lordship kindly see.
Yes, what is this matter?
Regarding this matter, the Moja, which has been excavations and executions of the sand from Darakasor's riverbed, is entitled to get that only those Moja. But whereas it in absence of the Bonkati Moja has not yet been approved by the state or nothing.
What
We
is
made
your-
an app-
what is
22
your
tender,
affectation of-
25.
What is your affectation of right?
Yes,
Mentality
yes.
of a writ petition.
Yeah, that's right.
Show me your affectation of right.
I made an application. That application is kept pending. Kept pending. Whether
The law is the
Your affectation of right.
either the
No.
state. Because
Show me your affectation of right.
Nothing.
Public.
money has been
If you say public, I'm giving you liberty to move a public
My
interest
lord.
litigation.
Nothing. No case in paragraph 2, kindly see.
public interest litigation matter may move. You'll also dispose of this matter with your observation.
Key observation.
It may be granted to.
Uh,
No, no,
You
no.
can withdraw. I
The
give you
application.
liberty to withdraw this.
No, your lordship, kindly record my submissions. No case has been made out.
Why?
Mr. Banerjee,
But
I'm accepting your
After my lord, conflicting, you are.
Mr. Banerjee, I'm accepting your
It is
submission. I'm
suggestion
not
of the court.
entertaining this rate, but is he not entitled to move a public interest?
Yes, yes, your lordship.
That is what he wants. He
Dispose
wants
it
to
of
be-
giving liberty.
So he wants to withdraw this with liberty to the Yes, next.
My lord, in this matter, my lord, I am for the petitioner, my lord.
Yes.
Affidavit of service. Your lordship kindly, my lord, directly come to page 25 of my application. My lord, I filed 28 application, my lord, of the Land Acquisition Act 1. My lord, and pursuant to that application, my lord, they have decided, my lord, your lordship kindly see page 25, last paragraph. So the petition for redetermination of collector's award under section 28A is allowed, and the present applicant Samuel Ghosh
Yes.
and
Then what happened?
Yes, my lord. Thereafter, my lord, your
So
lordship.
prayer has been allowed.
Yes. Prayer allowed. No amount is disbursing. Your lordship kindly see next page, my lord, 26.
Yes.
According to them, my lord, 4 lakhs of 44
is due to you.
Due to you.
Well,
But,
like,
my lord, thereafter, my lord, note, kindly see their note. No interest in between
That
the
is not permissible, my
notification and the award was allowed by the honorable tribunal in the judgment dated 30/3/2010.
It's not permissible
My
under
lord,
law.
your lord,
28A2, my lord.
let me say first, please. Your lordship kindly see the, my lord, page 25, my lord.
Yes.
Judgment dated 33/2010 of the learned judge at Howrah in Lele case number 195 of 2007. My lord, by this judgment, my lord, your lordship kindly see the judgment, my lord. Oh,
Page.
my lord, your lordship kindly my lord, direct my learned friend, my lord, to disburse the payment of 4,46,000 on ad hoc basis, and thereafter, my lord, recalculate with interest, my lord.
That is a separate provision, my lord.
No,
We cannot.
why separate?
Yes.
28(2), my lord, there is no provision of interest, my lord.
All right. Have you paid this amount?
Yes, we send it to the department for releasing the same, my lord.
When?
My lord, we send it on 19th May 2025, my lord. My lord,
You have determined this amount September 2024.
Lordship kindly.
So more than 1 year has passed. All right. Let us forget about that. You pay for this 1 year delay.
Lordship, there is no provision.
Pay this interest for 1 year delay. You have kept, after determining, you have kept quiet.
Because, my lord, this interest is accrued this, then we deduct the interest and we calculate.
No. All right. Let us forget about that. For this 1 year from determination of 23rd of September 2024, you have made a delay of more than 1 year. Pay interest on that.
28A, my lord, we have.
Not on 28A. From your determination, from this date. This date pay interest. You cannot keep quiet. Say, yes, after 10 years, I will take time. I will not pay interest. That cannot be accepted. So pay interest at least from 23rd of September 2024.
If there's a referral, if my lord, they agree with the interest, my lord, they can approach with his referral. 23AB.
No, not referral. I'm from your determination here. Yes, Mr. Banerjee, you are appearing in this matter. Yes. Why have you not released this amount?
My lord, we have
pay interest on this amount.
My lord, WIDC is the requiring body. My lord, we have requested them for
that release.
But they are party before your lordship. Kindly, but
maybe
No.
West Bengal
Industrial Development Corporation.
Who
They are the
appears for
requiring
that?
body. Mr. Shuddhodaya Badok appears, my lord. Kindly, I'll inform, let them do. They have to ultimately pay if your lordship.
It's all under your control, Mr. Banerjee. You take steps against
We
that
ask for the
corporation.
funds, my lord. They are
Dissolve
not
that
paying.
corporation. Mr. Banerjee, dissolve that corporation. Dissolve that corporation if they do not pay. You pay, you recover from that.
9th May, we ask for the money, my lord. Still,
they are not paying.
kindly
Mr.
give us some
Banerjee,
time.
you pay, recover from that or dissolve that
Kindly
corporation.
give us some time regarding disbursement.
Interest
My
is
instruction
at
is
least
that
23rd of September 2024, you have to pay interest. 1 year delay, you recover from that corporation. I will allow you, permit you to recover. You pay along with interest, you take steps for recovering that amount from the requiring body. I will make that provision. with you.
kindly allow me to come back after a week. I'll come back with the instruction regarding payment. And I'll also inform the IDC. They should be present because they have been served. But one thing, my lord, in this petition, they have, my lord, challenged the quantum, which they cannot do here, but they have challenged the quantum at the same time asking for release of the money. My instruction is that we have to pay. We have asked for the money, we have to pay. That is
yes, challenge saying that interest part he is entitled to. even if I accept your submission,
That goes to
yes,
section
now
18.
he said lastly that I am entitled to that, he is not releasing. But even assuming your argument, accepting your argument that he cannot claim the interest for a prior period, at least from 23rd of September 2024, you have determined that amount. At least from that period, interest has to
Under the Act, 9% and 15% from the date of the award.
date of this award, so you are reassessing this. So from this, you pay at 9%.
It's statutory provision, Lord. It has to be done. But kindly allow me to come back, Lord. And I'll also instruct, Lord, the requiring body to appear.
Milord, they are saying, Milord, 195 case. This is the judgment of the 195 my ordering portion.
কত কথা দেখাচ্ছেন স্যার?
ওটা earlier
এদের বললো এদের বলেছে তো 195 ফলো করতে যা
এই যে এখানে বলেছো
জাজমেন্ট রিলাই করলেন?
না জাজমেন্ট
Interest has also been provided for that, Mr. Banerjee.
yes milord
এটা এখানে দেখো 195 বলেছে
You have not given them that benefit.
এখানে বলেছে এটা
You have said that you have to go there. Why?
page 25
Same benefit 28A.
yes milord
See, please, you have allowed that, but you have said no interest in between the date of notification and the award was allowed by the tribunal. How do you say this?
If they agree, Lord, they have to challenge it in accordance with the statutory provision. But so far as
Mr.
the amount,
Banerjee, I will allow, I will give them liberty to challenge, but this amount with interest pay, I will give them liberty to challenge that.
This amount, kindly.
Be admitted, you cannot come out of that.
Our calculated amount. I'm not saying
So
that.
your calculation, you cannot come out with that. So if you say so, I will give them liberty to challenge that in a different proceedings or
Section 18. If they are not under law entitled to challenge,
that.
Lord, they have foregone their right.
Why?
28A, 28A subsection 2 says collector will recalculate. If they are aggrieved by the recalculation, then subsection 3 says they have to challenge in accordance with section 18. So another reference. Then those provisions will come in. Those 6 weeks, 8 weeks that will come in. Anyway, he's right. He will pursue. But
Milord,
this I have
Milord,
to-
their own judgment, own order, Milord, 25 page 25 last paragraph. According to the judgment of 30th March 2010, Milord, what is the judgment of 30th March 2010, Milord? What is the judgment, Milord? Learned judge, Milord, directed to calculate the interest amount also, Milord. Your lordships kindly see.
First year 9%.
First year 90%, thereafter 15%, and solitium 30%. Everything has been stated, and in their own judgment, Milord, they have decided it. Page 25, Milord.
When did you communicate this order, Mr. Banerjee?
21st
No,
May.
no. To WBIDC, 9th of
To him, because he has to challenge according to you. When have you communicated this to you? Him?
পরে কমিউনিকেট করেছি
Second May they have communicated.
না না
this matter.
সেকেন্ড মে নয় হাইকোর্টের অর্ডারেতে
No, no.
সেকেন্ড মে
Adjudication টা।
2025 জাস্টিস পার্থ
But
সারথী
20th August 24 order was passed.
21st May 20
No, when have you communicated to them?
21st May 2025, Milord.
as
They have
per order of the honorable
as per order of the Honorable Court, 2025.
21st of May 2025,
Yes,
and they have filed on 26th of June. Writ petition is pending here, challenging this.
Date of communication, কি বললেন?
Yes, yes,
Yes, yes.
page 22 page 22
Page 22.
yes.
21st May 2025 they communicated as per order of the honorable justice Partho Sarathy Sen.
When they have challenged, this writ petition is pending.
21st May 2025
They are within time, Mr. Manager.
Approved when they receive.
And the writ petition is pending, so they are within
They
time.
will pursue their remedy as per law. So far as the admitted amount, I am saying, Milord, that kindly give me some time to take instruction and come back.
1 week.
1 week.
The learned advocate appearing for the petitioner submits that
Milord, this amount should be paid on ad hoc basis, Milord. Milord, with interest they have not
wants some
calculated.
instructions, he wants to come back after a week.
On protest. The language is on protest. So they have to,
What?
they have
what
to
on
receive
protest?
it. Milord, section 18 for reference, they have to receive it on protest.
Yes, that is the
language.
That is their submission also that please pay this.
Ad hoc means they are challenging.
The learned advocate appearing for the petitioner submits that the determination made as per section 28 capital A of the 1894 Act is not in terms of the order dated
30th March.
না না 20th August 2020. Page 25.
তাদের জিজ্ঞেস করো আগে কমিউনিকেট করেছে কি? 20th of May তে করেছে।
No, the order of the
Collector, my lord.
not in terms of the judgment dated 30th of March 2010
Yes, yes.
passed by the land acquisition judge
Yes.
in LA Miss case number 195 of 2006. First up, the learned advocate further submits
Evidence service filed to take
every service filed in court today is taken on record. Yes, call the next matter.
27. Lord, I am for the petitioner.
Yes.
But I think, my lord, at this stage the matter is infructuous.
Infructuous.
Because, my lord, last occasion.
So I'm recording that. The learned advocate appealing for the petitioners. Yes.
28. In this matter, my lord, I am also for the petitioner.
Yes, Babu.
My lord, I filed 28 application, my lord.
Same thing.
No, my lord, that was not disposed of. My lord, when I served the copy of the writ application, they called me for hearing and my lord
Passed an
decided
order.
passed the order. But order has not been communicated. No award money has been disbursed.
No,
Nothing
you have
more.
said that they have communicated the order to you.
No, my lord. No. This is my supplementary evidence.
Order has been passed
but that's not as yet been communicated.
Communicate
But today or tomorrow, my lord, it will be communicated over telephone. I have instructed.
some disposing of this
My lord,
repression by
my humble submission, my lord. They, my lord, may be directed to, my lord, communicate the order with calculation sheet, my lord. No, yes, no. You are,
determined award will contain the calculation. That's the award
I
which
don't
has
know,
been
my lord, what order has passed over telephone. I have just informed.
my lord, on
Let them-
different
that
set
they have
Sir,
taken
let them
hearing.
communicate. If you have any difficulty,
Miller.
then
with calculation sheet, my lord. My lord, there are some, there are
Sir,
more than one.
you have
My lord,
moved the earlier matter. The redetermined award contains the calculation. What more calculation you
no,
want?
my lord. Practical, my lord, is thing is that, my lord, they are not. They are not giving calculation sheet, or they are not, my lord, communicating the order, my lord.
যদি দেয়
No.
তো ভালো
দেয় না।
চেয়ে নেবেন
কার সঙ্গে চাইলে দেবে না।
All right, sir.
I don't know, my lord, what order has been passed.
No,
What are the
when can you produce that order?
over telephone? Just I have been informed, my lord, by the officer concerned. On 14th, my lord, the order has been passed, but that has
14th
not
order has been passed. Ashun. The
Which dots in how many degrees? Don't take. Message करिए calling of that
Payment given of. Supplementary affidavit and affidavit of service kept on record, my lord.
Supplementary affidavit, evidence service kept on record. Yes.
And for the
দিয়ে দিয়েছি
Your Lordship, I am for respondent number 3 to 5
Yes, yes.
in this matter. I am appearing virtually in this matter.
Thank you. Yes.
Your Lordship, the matter is, Your Lordship, the land of the petitioner has been acquired by the railway authority for the dedicated freight corridor corporation of India. To be more specific, this land has been acquired under the Railways Act, Your Lordship, by the dedicated freight corridor.
What are you challenging?
The challenging is they have not given us an award till date, Your Lordship. They have received. They have, yes, under protest. It is on the environment as well.
No, you have said they have not passed an award and he is saying amount received. Unless award is passed, how can you receive the amount?
Let me just bear me 2 minutes. Your Lordship. What they have done is they have asked for a hearing over there. We have given the bank details and everything. After a certain period, we found that the amount has been credited to our account. We went over there. We have given a protest over there that you cannot, as a specific letter as well, the representation to give us a award copy. How this has been calculated? Why I'm saying so, Your Lordship?
You have not been provided with the copy of the award.
No, nothing has been disclosed.
Give the copy of the award.
Let them disclose it, Your Lordship.
Give a copy of the award. He is entitled to the copy of the award.
Why I'm saying, Your Lordship, because under the new situation, Your Lordship, we are supposed to be guided by 2013 Act. So the calculation, everything, schedule 1, schedule what?
Yes.
Because the
He must
matrix.
get a copy of the award, Mr. Ghosh.
That should have been done, my lord.
So where is that copy of the? Give him the copy of the award.
The matrix also says what is to be calculated. This is I have annexed all
Yes.
documents.
So he has to see whether it was correctly calculated or not.
It is, my lord, it is indicated in my instruction, my lord.
Yes.
Your lordship kindly takes up my instruction for once.
But, does the instruction say that the copy of the award was given to him? Please check up that.
Award has been finally prepared.
No, but do
12% interest per annum.
no,
From the
so
date of
give
notification.
him the copy of the award. He must know how you have calculated.
And my lord, it has also been added, my lord, that it is not acceptable. He is free to approach the, my lord, the.
No, if he,
But unless he knows about the
yes,
fact.
because he has to challenge. Challenge is before where he should challenge.
The arbitrator, my lord.
Before
Yes.
the arbitrator, Your Lordship.
Before the
20
arbitrator.
20
So unless he guess, because the time will also run from the copy of.
Order passed, not specifically. That will, may not let them an order be passed.
No, have you
Specifically
served? No,
directing.
Mr. Ghosh, have
May
you
not
served?
my-
If you have served, then the limitations will start from there.
My instruction does not speak about any service of the award.
So please take
Admittedly.
instructions.
Admittedly.
Please take instructions whether the copy of that is his only grievance. And if you say we will be serving a copy, I will record that. It
Currently
is
passes an order, my lord, if not served, is to be served.
Let it-
immediately.
Ghosh,
let it
don't
notice
keep it.
before the honorable court, Your
Don't keep
Lordship.
it vague. If not served, then there is a dispute. He will say I have served. He will say no, it has not been served. Please take
I'll
instructions.
come back with specific instruction, my lord, whether it has been served or not.
Yes, if you have not served, please serve him within a certain time.
My lord.
The
পূর্ব বর্ধমান, Your Lordship।
পূর্ব বর্ধমান।
Seventeen.
Immediately.
So I'm not passing any orders to that effect. Kilo.
And
Shall I keep this report, Mr.
My lord,
Ghosh?
my lord.
The report filed. The report. এটা ফেরত দিয়ে দিন, এটা নিয়ে লাভ নেই। রিপোর্ট ফাইল ওটা should not be done, Mr. Ghosh. Please tell them there is.
It is my fault as well. But I should have.
They are giving this. They also should not give it to you with this.
Your Lordship, affidavit of service.
So DA doing like this. Yes, next.
30, 31, 32, same matter, Your Lordship.
Your Lordship.
Yes. 30. Give your appearances. 30, 31, 32. Same. Please give your respective appearances.
Lordship will kindly record my presence also. Can we get it through the chat box?
All right, all right. ওটা দেখে নেবেন, হ্যাঁ?
Affidavit
Chat box দিয়ে দিয়েছে।
in all the matters of,
Chat box এ দিয়ে দিয়েছে ওনার appearance.
Your Lordship, affidavit of service in all matters of.
There is service taken on record. So up to 32. Yes, next.
I'm for the petition.
Yes.
And this is the affidavit service. All are served except respondent number 11, 12 refused to accept the
Refused is good service. What is this?
in removal of encroachment from the national highway road controlled by the state highway. I made representation, Lordship, page
Who is for the state?
23.
Who is for the state?
I'm not for. I'm for.
Private
respondent
party?
No, my lord, I'm not for respondent number 1 and 2.
1 and 2.
30, 31, 30.
Oh, Union of India.
Oh, I'm sorry. I'm
Yes.
sorry, my lord. I'm sorry. I thought it's continuing 30, 31, 32.
Oh, all right. Who is for the state?
No.
Nobody is for the state. Have you served upon the state?
I have served.
Mr. Bandyopadhyay.
We are the owners. I have stated in paragraph 2. দিয়ে দেবো, অবশ্যই দিয়ে দেবো। Encroachment of national highway controlled by the state highway.
Both Mr. Bandyopadhyay will appear. Yes. Mr. Senior Bandyopadhyay.
It will be disposed of by the district magistrate, both, my lord.
Both Mr. Bandyopadhyay will appear. Or one Bandyopadhyay, another Banerjee.
No, both. Both.
Yes. Who will consider this?
My assistant engineer.
Removal.
That's the engineer, no. But the national highways, my lord, under section 26.
No, this is not a national highway. This is says the PWD is under control.
Yes.
Maintained by the Public Works Department.
PW control.
আমি জানি না পিডব্লিউ কন্ট্রোল কিনা but a notification my lord lastly issued on 29th October conferring the power upon the district magistrate instead of the national highway. May I hand over it?
This is the national highways.
In national. It's a national highway. I don't know, my lord. I have not gone through the brief. The car control, PWD.
Yes.
Then my lord assistant.
PWD.
Then
Respond number 5.
What is the property?
I have stated in paragraph
a copy দিয়ে দিও
2473, 2476. No, LR plot number 3043.
3043, 3048.
Petitioners or
Petitioner.
petitioners claim to be the recorded
Don't please.
I'm for the petitioner, my lord. My lord, dispute regarding erection of boundary wall. I am the recorded owner.
Erection of boundary wall, dispute between
Dispute between some unknown miscreants who are basically the cultivators. Whenever an effort is being made to raise the boundary wall,
where is the inaction of the authority under Article 12?
my lord, we have requested the concerned BLR to arrange for an independent mapping. I mean,
Where is the provision under which statute?
section-
Private land will be demarcated. Please show me. Which provisions?
As per the record, I mean, Section 50 of the West Bengal Land Reforms Act, my lord.
Show me. It provides that a private land can be demarcated. Hey, it's a
There is no such provision, my lord. Nay.
For maintaining the records, my lord. So,
Please show me that the Land Reforms Act vests powers of the Revenue Authority to depute means to demarcate
private land.
Show me. Please show me the provision. Have you seen that provision?
I've seen that provision.
checked
My lord,
up that provision?
there is no specific observation to that effect. But my lord, so far as
Then an
continuing,
authority under a statute can only do those things which power has been vested by the statute. It cannot go beyond that. Unless you can show that the statute vests such authority with the power, cannot.
other than 144 application has been made,
The demarcation,
a report has
please
been filed by
approach-
the BLLRO.
Please approach before the civil court, demarcation, there it will be done.
My lord, I leave it to your lordship.
My lord,
Please show me. এই রুলসটা দিলেন তো একটা দিলেন না।
No, my lord, there is no such specific clarification.
নেই
There is no such specific clarification.
আমরা করতে পারবো না।
I cannot deny that.
তুমি 34 দিতে বলে গেল 34 দিতে
Which provision, which section you are talking about?
Section 50.
আরে 50 তে নেই mutation
50 is record of rights, correction of record of rights.
It is, my lord, for the purpose of preserving the
ওরে বাবা তাহলে
identity of that.
হবে না
What have you paid for?
My lord, the prayer is at page 11, my lord, prayer A.
হবে জোসেফ দেখে নিয়েছেন
You have brought a civil dispute before a
My lord,
revenue officer, not
there is
even
no
before the
civil
writ court.
dispute, my lord. Civil case pending here, my lord.
Pending.
pending নেই no
No civil case is pending.
Maybe, but civil dispute I am saying may not be.
yes
My lord, so far as
This is a
preserving,
civil dispute pertaining to a removable property.
yes
Show me the averment in the writ petition. What is the case made out?
my lord, paragraph 4, page 6, my lord. Paragraph 4 and 5, my lord.
পাইবেন
What is the plot of land of your plot of land? Is 932, 934 and 938.
Yes, your lordship.
And what is schedule B? Schedule A and schedule
My lord,
B?
two plots, my lord.
No, you are the owner of which plots?
Both.
You are the owner of 7 plots.
Yes, your lordship.
And
Brothers, actually. Two brothers, my lord. They,
so dispute between 2 brothers.
no.
So dispute with
My lord, the dispute is not with the adjacent owners as well. It is the cultivators who are coming in the way.
কি করে হবে
They are
cultivators means Borgadas.
local farmers, my lord. They are coming.
Where
They
is
are
the record of rights? Show me the record of rights. What is the classification of this land? What is the classification of these lands?
29 page
20.
অশোকদাস কোথায় রায়?
29 স্যার 70
আরে রায় হচ্ছে ন ক্লাসিফিকেশন অফ ল্যান্ড, মাই লর্ড।
What is the classification of land?
ভোগলাবন জল জল, ভোগলাবন জল জল, পেজ 29।
Jol is agricultural. Medipur.
রামনগর, পূর্ব মেদিনীপুর।
Yes, Purva Medipur is agriculture.
এগ্রিকালচার।
It's Jol. Then so agricultural land, how can you put a boundary wall?
Boundary wall.
How can you put a boundary wall around the agricultural land?
Well, some portions
আরে
are
করা
water
যায়
land
না,
and
boundary land তো
some portions are water land, my lord. So far as this
Jol is not waterland, sir. In Medipur,
জল হচ্ছে চাষের জমি,
it's an agricultural land.
the purpose of irrigation, my lord.
না এগ্রিকালচারাল ল্যান্ড, চাষের জমি।
Agricultural land, it's classified, stated, Shali in the record of rights, other districts, Medipur, it's Jol.
My lord,
Jol is not a water body. Jol is not for irrigation. There it's classified as Jol. It's an agricultural land. So agricultural land, you cannot put a boundary wall.
My lord, that is the main apple of discord between the
So that is why you are trying to any Borgadar?
no, my lord.
নো
No burgers.
পাওয়া যাচ্ছে না কোথাও।
The petitioner claims to be Yes.
55, I'm for the petitioner. This pertains to one Noyonjuli, which is a drainage system on a PWD road, at the side of the PWD road. Lord, in my writ petition, my lord, kindly sees page number 39, annexure P6.
Yes.
It's a pictorial representation, my lord. My lord would see that there is property of Sheikh Musair Rahman, which is the petitioner. My lord, then Sheikh Mehboob Rahman, who is the private respondent, and upon the Noinjuli PWDR land, my lord, he has constructed a shop. The picture of the shop is in the very next page, my lord. I've made representations before the authorities. The representations, my lord, starts from
You have
page.
served the private respondents.
My lord, I have served them, but they are not here. I have served them. I've missed my.
Where is the evidence service?
Missed my brief today. I'm doing it from my tablet. However, my lord, only praying for consideration of my representations, if at all be. I undertake to file the affidavit of service. All are served, my lord. By tomorrow.
Bandhavada, what do you say?
Let it be disposed of by the assistant engineer, my lord, to take step, my lord.
Where is the representation?
Page 31.
Page 30.
1.
The petitioner claims to be the owner of
I am for the petitioner in this matter. My land was acquired for extension or widening the NH 434 in the district of Malda. Land were acquired.
NH 34.
NH 34 at Malda.
You are for?
I'm for the National Highway Authority.
Below, during the such extension, my land was taken along with demolishing the structure and the business shop of the petitioners standing thereupon. Lord, accordingly, as per direction, we applied for the compensation, submitted all the documents. Lord, land compensation was given to us, but no compensation was given in respect of the structural damage. As a result thereof, we made a representation. Nothing was done on the basis of the representation. I had to approach before this honorable court. When this honorable court directed to reassess the compensation amount. Lord, your lordship, kindly come to page number petitioner 64 for a moment. 64 for a moment.
Yes.
64. Well, I applied, and then, my lord, the internal communication is at page 69. Well, I'm sorry, my lord, 69. My lord, but from the available records, my lord, second paragraph, it is found that LA arbitrator passed an order relating to the LA case number such and such on Atho, in which the provision is laid down in para 4 denotes as D of the said order that as regards petitioners for reassessment of structure, if any, executive engineer PWD NH division will verify the assessment sheet in accordance with the prevailing schedule of reference to 3A notification and submit the report.
Yes, what happened thereafter?
Nothing was done. Then I made a representation. Then, my lord, further communication is, my lord, petitioner, my lord, then your lordship kindly come to 69 for a moment.
Yes, 69 was
69
placed.
it was done. Thereafter, I made representation after representation.
Nothing has been
Till
done.
date, nothing has been done.
Yes, sir.
What I am praying at this stage, Lord, your lordship may dispose of the writ application, directing the respondent authorities to reassess the compensation for damage of my building.
Yes.
Also, the respondent number 6, that is the Executive Engineer Public Works Department. With respect to structures, he is the concerned authority who will go through the assessment sheet. If any reassessment is required, he will place that before the competent authority.
Yes.
Lordship, let that direction be passed. We have no difficulty.
Who is from the PWD? You have not made PWD.
No, it is not PWD, my lord.
Respondent number 6.
Executive Engineer of the Public Works Department, National Highway.
That is, my lord, NH1.
You are representing the 6th respondent.
No, so I'm respondent number 4. That is
Yes.
Project Director, National
Who is
Highway
for the
Authority.
Executive Engineer of Public Works Department? Have you served upon the 6th respondent?
He was directed by the Assistant Commissioner.
Yes, yes. Have you served upon the 6th respondent?
Lord, in fact, I have served, but I am not in a position to hand over show the receipt because my learned junior has forgotten to bring the brief. This is the predicament on my part. I should be very frank.
Yes, Mr. Bandyopadhyay, who is appearing for the Executive Engineer PWD? Says yes,
Well, I don't know whether the executive engineer PWD is the authority. In fact,
Yes,
the project officer.
69 it says.
69 says the NH division.
Executive Engineer, PWD, NH Division.
NH division. It has a address to him. Project officer NHI PIU Malda. Assistant Commissioner sent an entire document to him and requested him to look into the matter. And
Lordship, an award had been passed. The award.
No, award has been passed, but not for the structure.
Not for the structure.
Reassessment.
Yes, your Lordship.
Reassessment has to be done
by the Executive Engineer.
Yes, what has been
PWD
done from April 2024-5?
Lordship.
The
file in so that it may be.
Then I'm making it day after tomorrow. But tomorrow jaga affidavit service day after tomorrow.
As your lordship.
Yes, next.
36. My lord, item number 36, my lord. In this matter, I am appealing for the state, my lord.
37, yes. You are appearing, yes.
36
Lazy in respect of a plot.
It was appearing online. 36. In 36.
Because we have for the state, my lord.
Anyhow,
yes.
Lordship, I'm for the petitioner, Lordship. The petitioner is a lazy in respect of a land, Lordship, for 99 years, Lordship, granted by the Shantiniketan Sriniketan Development Authority. Now, Lordship, in the year 2000, it was in the year 1994. In the year 2002, I applied to them that I wanted to assign that land to some third party. Such, Lordship, assignment was, Lordship, approved, and they directed us to submit some additional documents, which we also did, Lordship. But thereafter, Lordship, they said ma'am about that matter. Now, suddenly, Lordship, I have obtained an application, a Lordship notice for determination of the lease on the ground that I have not made any construction and the plot is still vacant. But Lordship, in that.
Now have you replied to this?
Yes, I have, Lordship. That is at page 40, Lordship.
Yes, what is the decision on this?
Nothing, Lordship. Till date, nothing has been stated by them. That is pending.
No. Notice.
No, can you see page 27?
27.
Page 27, cross 23 of the lease deed.
No, that is the clause 27. Maybe
the terms of the lease.
you have served a notice for
Yes.
determination.
Lordship,
That's page 38. That is page 38.
That within 45 days, I have to submit in writing about my reasons, Lordship. The second last paragraph.
Yes.
That I did, Lordship.
Yes, he has submitted a reply.
Yes.
If he has submitted a reply to the notice, you have to take a final call on that.
Can you see page 39? Whereas the demised land as vacant as present appears not of the lease, in line with the spirit of the terms and conditions of the executed district, and thereby the purport for which the legal interest conferred upon the lessee have been frustrated and liable to be determined. Immediately as the order will be communicated to lessee concerned and with the time and for the
Chakravarti, the
receiving expression for the authority to
Yes.
So what is page 41?
41 is, Lordship, based on this notification, Lordship, this notice for determination of lease was issued. And Lordship, my answer is at page 42.
Please give me a minute.
Yes.
Please give me a minute.
This decision was taken by the urban development. On the development authority.
Where is the lease deed?
Yes, Lordship.
Which clause, Mr. Mukherjee, you are referring to?
Lordship, it starts at page 17.
Page 20, cross 23.
Clause 23.
Yes, page 27. Within 3 years from 1994. This deed was executed in 1994.
Where is the clause for re-entry? Clause 30.
Yes.
The right to enter to re-enter possession demonstrated current price of the land
start with the default observations of prior Lessee and after conditions on our part. 1994 lease was executed. Till that 2005, no construction has been made.
Yes, what is the ground for your not making this construction for this long years?
Lordship will kindly come to page 35.
Yes.
Lordship, in 2022, Lordship, I made an application that I want to assign it, transfer it. And Lordship kindly sees at page 35, Lordship, it was approved in pursuance to the 144 authority meeting held on
Where?
page 35. Your transfer case has been approved by this authority.
Oh, has been approved.
Yes, the above matter will be sent to Urban Development and Municipal Affairs
Your
Department.
transfer means
Wanted to assign it to a
who are
third party.
you?
I am the Lordship
You are
lessee.
the original lessee. So your prayer for transfer was approved.
Approved in 2022.
Yes.
Thereafter, and I was directed to further submit further documents. Lordship kindly sees
For assessment of the transfer fee.
fee and yes. Next page, Lordship. In 20
You have submitted the required
yes,
documents.
yes. Now suddenly, Lordship, in 2025.
2023, 13th of February 2023.
Yes.
Yes, Mr. Mukherjee. So your his prayer for transfer was allowed.
But that does not mean that I cannot deviate from.
Mr. How? Once you have approved the prayer for transfer, how can you now fall back on that clause?
Because we have
Mr. Mukherjee, when you have approved the prayer for transfer, Mr. Mukherjee, when can you approve the prayer for transfer? Now, please, there is a lease. You have given a lease. Lease.
Terms and conditions is there.
Yes, transfer of possession. There are certain conditions in the lease. One of the condition is that the lessee has to make construction within a time period as indicated in the lease. If not, you have been empowered to re-enter.
Yeah.
There are two clauses: you can re-enter or you can charge at the current market price. So these are the two clauses. So it's or. So you have the liberty to choose one of them. So you could have re-entered. You have not re-entered. Till the time they have exercised their right to assign. Assignment is permissible with permission. Cannot assign or transfer or sublet without permission. But with permission, this transfer assignment is permissible. He has sought for your permission for transfer. Now, when the right to transfer will be there, till that time, the right of the lessee continues. He has a right to assign. If the lessee's leasehold right stood expired or terminated, whatever be it may, he or she cannot transfer his interest. So your approval means till that date, you have not terminated. So if you have not terminated, you have asked him to produce certain documents for the purpose of assessment of the transfer fees. He has done that.
One chapter, but whether he has followed the terms of the lease agreement.
Mr. Mukherjee, you cannot now fall back on that.
No.
Cannot fall back on that, Mr. Mukherjee. Mr. Mukherjee, you have waived your right. Yes. How could you? You cannot go behind this document. You have approved the prayer for transfer. Approval of the prayer for transfer shows that till that date you accepted him to be a lessee. You could not have terminated the lease by falling back. The 3 years you have not constructed. It's not open to you after that.
This is for 2025. And this
Mr. Mukherjee, he has done. Now it's up to you to assess the transfer fee. There was no default on their part. They have complied with your request. What are you saying? They have complied with your request, and you are sitting tight and you are saying for your fault they will suffer.
No. Why he has not made the construction? Question is why he has not.
Mr. Mukherjee, now you cannot.
Construction is one thing, And transfer
Mr.
over
Mukherjee,
one thing.
Mr. Mukherjee, after allowing this, you cannot. After allowing this prayer for transfer.
Transfer when? Transfer may be accepted, may not be accepted.
No, you have accepted. You have accepted his prayer. Subject to, please see page 35. What are you saying? As approved.
Can you see page 35?
Yes, you're approved.
Just 1 second. In pursuance of the 114 authority meeting held on such and such, your transfer case has been by whom? By
With the authority.
Can't see. Something with the development authority.
Yes.
Urban development authority, two different things. Lease executed by whom? By the state
Yes.
government.
Lordship, kindly sees the lease at page 17. Between the governor of the state of West Bengal, represented in this case by the Sriniketan Shantaniketan Development Authority.
So
Yes.
that authority can, Mr. Mukherjee, you cannot say that because you have the right, the authority granting the lease only has a right to give permission to transfer.
And this decision has been taken by the home.
Please show the minutes of that meeting. Please show the minutes of the meeting. I'm staying this order. Cannot do this. Or if you want the transfer fee, please assess the transfer fee.
Without instruction, I cannot.
When can you come with the instruction?
Because we are all the.
What further steps they are contemplating, Ms. Mukherjee, Chakraborty?
Lordship, any day, Lordship, they may throw me out. They may give me notice to evict, Lordship.
Stay, not to take. So which is to be stayed?
This notice, Lordship.
Which notice?
Notice of determination. That is in page 38, Lordship.
Notice of determination of release cannot be set aside by the date court.
Not set aside, but state. It
Yes. This is an inaction. This is an overaction on your part. After allowing this, you cannot.
It is a commercial transaction, not statutory transaction. There is a certain of decision I have.
Yes. I'm aware of those line of decisions. There is no disputed question of fact here. Here, admittedly, from the document, it appears you have approved the transfer. If you can come back tomorrow,
No, I shall have to get it from Bolpur something.
I can keep it tomorrow. You come,
I will
but
not get
I will record your submission that you will not take steps till day after tomorrow. I can keep this matter
I shall have
tomorrow.
to take instruction from Bolpur something.
Yes. So it's Mr. Mukherjee, you got telephone. You can take.
Development. They will communicate to the Bolpur.
Kindly grant stay, Lordship.
The petitioner Which date will be convenient?
Eight.
10th, 8th. Chakraborty 8th. 8th.